Noting the time and the presence of quorum, I'd like to bring this March 20th, 2023 meeting of the Acton Select Board to order. We'll start with resident concerns. Any residents who have issues not on the agenda, please come forward.
Good evening. Thank you. Alyssa Nichols, 76 School Street. I just wanted to take the opportunity tonight to announce that I'm running for Select Board, and I hope that everyone has a chance to visit my website, alyssaforacton.org. I'd also like to ask the board or town staff to get the election date, April 25th, on the town calendar. It's not up there yet, even though all the election information is there. And once we're past the deadline for withdrawals, I'd like to see the candidates listed for all of the offices. That'd be great. Since we don't have a paper, it'd be super helpful to have that info on the website. Thank you.
Thank you.
So my name is John Norton. I live at 133 Central Street, and I am also a candidate for the Select Board, and hope you consider me on October 25th, on April 25th. Thank you.
Thank you.
Tara Faggers from West Acton and Mass Ave. Two issues. My first one is the 100 Discovery Way. I know it's on the agenda, but the hearing is closed, and so we're not allowed to talk at that time. Or are you going to consider reopening the hearing? Can we talk about that at that time?
I will be asking for a motion from the board to reopen the hearing.
Thank you. So my other thing is sort of like I'm not going to name any names, but I've noticed that there seems to be some misunderstandings about the law regarding committee and board members are in charge of their own agendas, and they're in charge of who speaks at meetings. And so I want to make sure that, or just remind people to be aware of that, that yes, staff might want to request something to be on the agenda, but it is the board member's decision whether that goes on the agenda or not. And of course, everybody trying to be collaborative, we'll take those into consideration. But there is no staff that's in charge of boards and committees. And so I've heard those words used, and I hope people will stay away from them because they aren't in charge of the boards and committees. We, the people, run the town. And as appointed representatives of the Select Board, the boards and committees under MGL have the right to control their own agendas. Also, I've heard liaisons say, more than one liaison say, boards and committees I'm in charge of. As far as I understand, the liaison's role is to communicate back and forth and help resolve issues, not to run boards and committees. And my last thing I'll point out in this regard is that on the town website, if you go under government, it goes to a whole list of departments. And all the boards and committees, all the hundreds of people that are on these boards and committees are under one button, boards and committees. All the other departments show up. So it's almost like it should say departments and staff and boards and committees. So as if to say that, yes, there are people that run the town besides the departments and staff. Thank you so much.
Thank you.
Hi, good evening. Martin Benson, 21 Deacon Hunt Drive. This past week, the Supreme Judicial Court of Massachusetts ruled unanimously in Barron v. Colenda that the use of, quote, civility restraints on the content of speech at public comment sessions in a public meeting are forbidden, end quote. The court reasoned that the Southborough's Board of Selectmen's use of a, quote, civility code, end quote, to end public comment period violated Articles 16 and 19 of the Massachusetts Declaration of Rights. In their decision, the SJC wrote, quote, for the reasons set forth infra, we conclude that the public comment policy of the town of Southborough violates rights protected by Article 19 and, to the extent it is argued, Article 16. Under both Articles 19 and 16, such civility restraints on the content of speech at a public comment session in a public meeting are forbidden. Although civility, of course, is to be encouraged, it cannot be required regarding the content of what may be said in a public comment session of a governmental meeting without violating both provisions of the Massachusetts Declaration of Rights, which provided for robust protection of public criticism of governmental action and officials, end quote. The history of Article 19 traces back to the colonial era, as it was drafted by John and Samuel Adams to guarantee citizens the right to address their governmental leaders. The court further elaborated, quote, Article 19 reflects the lessons of the spirit of the American Revolution. The assembly provision arose out of fierce opposition to governmental authority, and it was designated to protect such opposition, even if it was rude, personal, and disrespectful to public figures, as the colonists eventually were to the king and his representatives in Massachusetts, end quote. The Acton Select Board must take notice of the Barron decision and its implications, which reaffirm the rights bestowed to the citizens under Articles 16 and 19 of the Massachusetts Declaration of Rights. This decision underscores this board's shortcomings in a number of actions over the last several years. These include the following. 1, the Select Board's July 2021 Respect for All statement, which the Select Board cited as cause to justify their illegal vote to remove Dave Lunger from the Acton 250 Anniversary Committee. 2, Mr. Martin's refusal to allow public comments during DEIC meetings because he was concerned about the content of public comments. 3, Ms. Nagaretti's proposal for a code of conduct for elected officials. 4, Mr. Martin's actions at the January 21st, 2021 meeting of the Acton Select Board. When acting as clerk, he disconnected the Zoom connection of speakers whose views he disagreed with during public comment. 5, Mr. Snyder Grant's act of calling a point of order for the purpose of stopping Scott Meyer's public comments, which were critical of Mr. Martin during the Select Board's December 19th, 2022 meeting. 6, further gleaned from a records request is a January 8th, 2021 letter from Mr. Martin to Superintendent Light, in which Mr. Martin offers, quote, to help moderate meetings behind the scenes, end quote, during school committee meetings. The following year, the comments of speakers who spoke critically of the decision to retire the colonial mascot were often muted in the public broadcast of school committee meetings. 7, the recent practice of town moderators implementing speech restrictions during town meetings. So there will be no further violations of Massachusetts law. Town council should appear in an open session to share her recommendations and respond to residents' questions. The overarching issue in this conversation is that there must be an adherence to diversity of opinion and no further viewpoint discrimination. Lastly, Mr. Mangiarotti, I have still not received a response from the town as ordered by the Secretary of State in case SPR 23-0175 in response to my records request of 4/20/2022. Any update on whether one will be forthcoming? Thank you.
Thank you. Okay, noting the time, we will defer the chair and town manager update for a bit. We have a public hearing set for 7:05 p.m. Under Mass General Law 140, Chapter 40, Section 22, the Acton Select Board will hold a public hearing on March 20th, 2023 at 7:10 p.m., continued from March 6, 2023, in the Francis Falkner Hearing Room 204, Acton Town Hall, 472 Main Street, and by video conference and call-in for a livery license for Rashid Transport Incorporated, located at 57 Hosmer Street, Acton. Login instructions for computers can be found here. For a computer, please click on the link to join the public meeting, actonma.gov/meetings/SB, or from telephone dial 646-876-9923 and enter webinar ID number 503-918-785. Telephone users may dial *9 to request to speak after joining the meeting. Computer and app users may use the raise hand feature to request to speak. Is the applicant present in the room? Please come forward, sir. Push the button.
Good
Yes.
evening. Thanks for having me.
Yes, could you introduce yourself and explain your business?
My name is Rashid Sharif. I live on 57 Hosmer Street. I'm asking Select Board in the town of Acton to please give me the opportunity to grant me a livery license so I can provide a car service and a limo for the residents of Acton.
Okay, thank you. Questions from the Select Board? David?
Hi, thank you for coming in. Am I to understand from your statement that you're going to operate two cars, one like a taxi and the other a limo, and maybe that means going to the airport or something?
Yeah, it's going to be one SUV Suburban 7-seat for now.
So just one vehicle? Thank you.
Just one.
Any other questions from the board? Any questions from the audience? Okay, I'll entertain a motion. David?
I move to approve delivery service license for Rashid Transport, 57 Hosmer Street.
Can I get a second?
Second.
Moved and seconded. Discussion? Okay, all in favor of the motion as read by Mr. Martin, please say aye.
Aye.
Opposed? Abstentions? You are approved, and hopefully you will run a successful business. Thank you for coming in.
Thank you very much.
Good luck. Okay. As most everyone recalls, we closed the hearing regarding the special site plan special permit 7/12/2022-487, 100 Discovery Way at our last meeting. There has been some new information that's come forward. So I would like to see if the board would be interested in reopening the hearing to hear the new information and have an opportunity for brief comments regarding that new information. David?
Just a point of order, Mr. Chair, can we reopen the hearing without notice? I know we can deliberate now. We don't have to notice that, but can we, I don't know the answer, actually. I'm not, no malicious intent or anything. I don't know if we can reopen the hearing without notice.
We have counsel present.
The answer is yes. I think it's fairly within the scope of the board's deliberation that things might come up that you might want to reopen the hearing for.
Thank you. David?
I move to reopen the hearing.
Okay, move to reopen the hearing. Got to have a second.
I'll second.
Okay, moved and seconded to reopen the hearing. Discussion from the board. Jim?
I was wondering if there was particular information or material that you particularly wanted to reopen it for, just so I had a sense of what we were headed towards. And if there was, areas that, I guess that was my question. Because I had some stuff I wanted to discuss too, but I just wanted to understand what the shape of things was.
Planning staff is here in the virtual building, but we have received several emails and messages from residents, from the applicant's counsel, or from the applicant. There was a decision by the Board of Health that occurred since your last meeting, and several other correspondences that have been received by either the Select Board or by the Planning Department related to this project that aren't in the public record since the record ended when the hearing closed last meeting.
I'll observe also there's was a recent Attorney General's office decision regarding a situation in the town of Wendell, Massachusetts that we might be referring to. And is the Board of Health, and there also was some discussion about a subdivision issue from 1980. So there's quite a bit of new information that's come forward. So We've got a motion and a second to reopen the hearing. Unless there's further discussion, all in favor of reopening the hearing, please say aye.
Aye.
Opposed? Abstentions? Okay, we're reopened. Yeah.
Kristen, our town planner, Kristen Guichard, could you please provide an update on where we are, please?
Hi, good evening, select board members. So there were 3 items, I think, mentioned by John and Chair Dean. Charter, there was the Board of Health's hazardous materials permit and conditions that the board may want to consider reviewing and determining whether or not those are conditions that they feel comfortable with, or if there are additional conditions they might want to consider if the board is inclined to approve a decision. There are also minutes of that Board of Health's meeting that transpired after the close of the hearing. And then there's also the Attorney General's letter regarding the town of Wendell, which was submitted by the applicant, that has transpired after the close of the hearing. In addition to a subdivision decision that was from 1985, originally mentioned by resident abutter Rachel Wilson, and then more recently discussed in a letter submitted by the applicant, again, after the close of the hearing. So those were some items that we thought would be important to review. There were also some questions I know that Select Board member Jim Snyder-Grant had posed, and so there's additional responses from the Deputy Fire Chief that I believe may be interesting for the board to review as well.
Okay, thank you. David, you've been sort of on point on this. Would you care to start the discussion?
So I'm not fully aware of all these things that have been brought up. I'm happy to review the whole thing, but maybe if, these new things, we should take one by one. So I was not, if I didn't know that we were doing this, I would have prepared for those things, but so I'm not aware of all those, the details there.
That's fine. Well, why don't we start with, I think, the most recent. I understand there's been some communication from the Deputy Fire Chief. John, would you like to speak to that?
Yes. So there was a question asked about how the fire department would respond to some of the concerns raised early in the hearing related to biannual training and responding to the site in the event of an emergency. And so the fire department provided a little bit of language this afternoon. It's fairly long. Do you want me to read the whole thing? Or I guess that's the only way to do this. Biannual training with the fire department should include all 4 groups and likely mutual aid responding companies. When discussed with Mr. Joshua Laraski, he indicated that this could be accomplished. The current comprehensive health, safety, and emergency response plan is incomplete and only a template, with the need for significant information to be added regarding an approach to an incident at the PESS. Should a fire occur, it is likely to burn to completion, though may be contained to specific cabinets, and current best practices indicate that it may be best to let it burn, as lithium battery fires are difficult to extinguish for a number of reasons and would produce significant runoff, which would likely dilute materials. One concern of the current site plan places the nearest extinguisher within 100 feet of the BESS within the exclusion zone. NFPA recommends that for residential and smaller scale commercial systems, on-call trained personnel need to be made available to assist first responders and address discharging of stored energy in batteries for disposal. The ERP should include NFPA recommendations as follows. and she cites, the Deputy Fire Chief cites NFPA 855 4.16.2, fire mitigation personnel, which I can read. When in the opinion of the AHJ is essential for public safety that trained personnel be on site to respond to possible ignition or reignition of the damaged ESS, the owner, agent, or lessee, one or more fire mitigation personnel as required and approved at their expense. 4.16.2.2, these personnel shall remain on duty continuously after the fire department leaves the premises until the damaged ESS is removed from the premises or the AHJ indicates they can leave. And then 4.16.2.3, on-duty fire mitigation personnel shall have the following responsibilities. Subsection 1, keep diligent watch for fires, obstructions to means of egress, and other hazards. Subsection 2, immediately contact the fire department if their assistance is needed to mitigate any hazards. Subsection 3, take prompt measures for remediation of hazards and extinguishment of fires that occur. Subsection 4, take prompt measures to assist in the evacuation of the public from the structures. And then further, this is commentary from the Deputy Fire Chief. One of the fears of many is the production of HF gas, which the Acton Fire Department does not currently have the technology to detect levels or the proper PPE to work in such an environment. Any emergency response would likely involve the deployment of the State Hazardous Material Response Team with an approximately 1 hour or more response time. Then further, there's a question about the design criteria specific to energy storage, and the response from the fire department is firefighting and emergency response to BESS situations is a fairly young science, and much is yet to be learned as to how to deal with emergency events involving BESS. So those were the comments from the fire department that were received today, and that is in an email that we can put wherever you'd like.
Okay, thank you.
And the second question from today was not from the fire department, or not about the fire department, but it was about trees. The question is, I'd like to see a map that shows the clearing zone, a map of every tree outside that zone that will be removed, and a map related to the tree removal and notifications of approval. And then the planning staff put together a response that said, the plan shows both a limit of clearing and a limit of work. The yellow line follows the low and LC. I mean the low LWO, which is limit of work, and LC is limit of clearing. So basically, there's a graphic which can be submitted that shows the limit of work and the limit of clearing. The red cloud area is an additional proposed landscape area. Currently, the plan state that they would defer to the town planner on the species and planting locations. The board could consider adding a condition to require this area be planted with specific species of evergreen trees spaced a certain distance apart if they find that the existing vegetation is not sufficient and would like something concrete in the decision. Those are the two questions that were answered this afternoon.
Okay, thank you. I take note that the applicant is here, and I know that the board did receive, and it has been posted, the rather extensive letter that you sent forward with a couple of thoughts that you wish to bring forward to us. Would you like to come forward and elaborate on that?
Thank you, Mr. Chair and board members. So we submitted a letter through our counsel, Tad Hewer from Foley Hoag, last Thursday, just addressing some of the items that have been mentioned here that occurred between the close of the hearing and tonight's meeting, as well as just some additional comments, again, that have been mentioned and that we wanted a chance to respond to and didn't have the opportunity to prior to the close of the hearing. So if you have a copy of the letter, just briefly going over the comments. So the first item we wanted to discuss in our letter was the Board of Health's decision and associated conditions. A list of those conditions were submitted with the letter as an attachment with statuses on each of them and estimated dates of when we expect to close those conditions and satisfy them. We wanted to just reiterate to the board that there was extensive review and discussion with the Board of Health on all aspects of the site, the equipment, safety and health. The conditions were fairly extensive. I believe the board stated they were the longest list of conditions they've ever approved on a project. And we felt that based on the board's feedback in that discussion that those conditions were sufficient to the board's decision to mitigate against any perceived impacts for health and safety to the residents or the town of Acton. And we wanted to make sure that that decision and those conditions were submitted for the record. We did want to make reference to and submitted the decision the state AG's office issued on a battery storage moratorium in the town of Wendell, Massachusetts. We felt this was just additional information that was good for the board to take in consideration when it comes to standalone battery systems, how the state views their protection under zoning, and the thresholds by which towns should be looking at them for permitting. And that further just reiterates the decision we received from the Acton ZBA on December 6, 2022, reiterating that the system is in fact protected under Chapter 48, Section 3. We also wanted to state there was a question raised on the subdivision from 1985, which contained a provision limiting the uses on the property to those permitted in the light industrial district in Acton. At the time of the subdivision, the parcel was zoned light industrial. I won't go and restate the arguments that our attorney Tad Hewer concisely elaborated on in our letter, but for one, the restrictions on those uses in a subdivision plan is invalid or inappropriate and unenforceable in our opinion. Regardless of that fact, if you were to look at Acton's bylaws today, again, the property was previously zoned light industrial at the time of the subdivision. It has since been rezoned to OP2. In Acton's current bylaw, under both zoning districts, the warehouse use is allowed by right, which the ZBA determined our proposed use is classified under. So even if the provision were enforceable, we would still be in compliance with it. The last item in our letter we wanted to go over was just reiterating for the board the fact that Blue Wave feels that we have addressed all the criteria that are outlined in the bylaw for a site plan special permit, the various design standards, parking, visual impact, consistency with the master plan, the uses permitted on the site, and again, most importantly, the fact that we felt that the proposed site plan, its setbacks from abutters, the various discussions, conditions laid on us by the Board of Health, all together when taken into consideration, and taken into consideration the fact, in comparison to other systems in town and other comparable uses, that we are in compliance with those criteria, that we protect against adverse impacts to both public health and safety and the environment, and that we recommend and kindly request that the board approve the project on that basis. So that's the overall content of our letter. Unfortunately, our counsel, Tad Hewer, could not be present tonight. So if there's any questions on any of the specific legal findings or arguments that do arise, and the board seeks resolution on, we would just request in that event a continuance to answer those, just given that his absence is unfortunately unable to attend tonight. So with that, I'll stop there.
Okay, thank you. Questions of the applicant by members of the board? Jim.
Just to follow up on the tree question, which we got an answer to. The answers we got have mostly been about trees to be added, and I feel like the responses to those have been adequate. The question was more about the trees to be removed, which there still seems to be some mystery about, at least in my mind. So I guess the questions in my mind are, when I went out to the site yesterday and tried to understand the tagging, there seemed to be different colors of tags, and there seemed to be some large trees that were either within the limit of work or just beyond the limit of work that were really tall. It seemed like maybe they should be removed, but I didn't see that marked. It seemed like it would be more straightforward if we had a map of the larger trees to be removed that we could introduce into the record and then make it a condition. The other thing related to trees that I didn't quite get clear about was what are the range of impacts of a tree that falls on this kind of energy storage system? So I guess those are my two questions.
No, thank you for the questions. In regard to details on tree cutting and planting, so to reiterate, in the proposed limit of work that's on the site plan, every tree within that limit of work is proposed to be removed. So all clearing and grading within that, it will be totally cleared and graded within that limit of work. To clarify in terms of the flagging that's present on site, we initially went out and flagged some trees. We had our surveyor go out and confirm flagging. So there's the stakes that are in the ground that have the purple or pink and blue flagging. That's the limit of work. We also have flagged some additional trees with orange tape that we felt were on the edge or might need to be removed. If there's maybe ambiguity around certain trees like that are on the limit of work or maybe just outside of it, we're happy to clarify that or maybe flag additional trees if there were certain trees that were causing confusion and, hey, this one is 5 feet away and it wasn't flagged, or this one was on the line and was flagged, or we wanted to be clear that everything within the limit of work is going to be removed. Our goal was that anything outside the limit of work would be monitored after construction for any impacts. We would monitor that for a period of time. Likely what we'll do is consult with a state forester for, take the recommendation on a specified amount of time to monitor tree health in the perimeter of the site for construction impacts to any additional trees. We don't want to, in an effort to reduce our impact, we wanted to not propose any unnecessary clearing beyond the limit of work, but obviously state that in the event clearing or additional trees have to be removed due to construction impacts, that we would do that. And again, if there's confusion over maybe which trees are of potential concern, we can clarify that or provide, go back out, double check, flag some additional trees if there's, room for ambiguity. And then your final question was just in regard to, sorry, could you mind repeating the last part? Yeah.
So if a tree falls on an energy storage system, what sort of noise does it make?
Sure.
What happens?
Sure. So the storage containers the batteries are housed within steel storage containers. So if a tree were to fall on a system, that would obviously produce a sizable crush impact depending on where and where on the site it fell. But let's say it fell on an actual enclosure. As part of UL 9548 testing, one of the things they test for is what happens when battery cells are, penetrated by an object. So they do a nail test to see what happens when a cell has a nail puncture through it. Then that result is assessed for. Typically, the concern is, does that cause thermal runaway, or does that cause a thermal event that could lead to thermal runaway? The results of the UL 9548 tests we've shared, so in the event of a tree falling on a system, the batteries, the cells themselves within the enclosure, if they're crushed, there could be a potential that, well, certainly if they're entirely crushed, they wouldn't be necessarily entering thermal runaway, but say there were compromised cells structurally, that could cause them to enter into, say, an agitated or elevated thermal state. Again, as part of the UL 9540A testing, if conditions arise in cells such as, from a puncture test or other conditions that might cause elevated thermal conditions, to pass UL 9540A, you have to demonstrate that that thermal runaway will not spread. So what we assume and predict will happen in that kind of scenario is that obviously the containers that would be struck by the tree would be compromised. We would have to go out and respond to the site in that event. Let's say it's somehow struck, a part of a container, so some cells within an individual enclosure were compromised, but not all of them. The results of the UL 9540A testing indicate that there shouldn't be any thermal conditions or a situation that arises that would cause widespread propagation of thermal runaway. So obviously we would have to respond to the site. We would want to make sure, there's a proper, my assumption would be there would be a proper hazmat response to any kind of it's an emergency event, just like a fire would be. And we would go out to the site, assess the damage, but there's nothing to indicate that that sort of damage would cause a larger fire or any kind of larger safety event.
A couple of follow-up questions. Again, about the site. Do you know those two orange traffic cones that are now sort of at the front left side of the site? I couldn't understand what those were.
You're saying just off the parking lot?
Yeah.
Yeah, so those were set there as part of the stormwater peer review. We dug just 2 test pits on the site as part of closing out stormwater peer review. So those were just some test pits that were dug, and there were cones there originally for the equipment that was on site. So.
Okay. And the other follow-up question was about the 4950A test, which I found really helpful to read through. So thanks for sending that on. So my understanding is you've got these individual cells, and they're arranged in a module, and that the test involved, forcing one of those cells to be heated to the point of failure, and the failure spread sort of horizontally, so to speak, to the other cells, the 9 or so cells in that row, and then didn't spread to the other rows of cells above and below, or to the left and right of it. First of all, am I reading that right? Was that?
Yeah, that's correct. So the UL 9548 test starts at the cell level, and then it's effectively a series of fail tests. Like if you fail, you proceed to the next level, all the way up to the unit level. So what you're describing is correct.
Okay. So a concern I had was that a tree crash could, it seems like it could rearrange the location of the cells in relation to each other. Bending, folding, collapsing, such that the spread of the thermal runaway would be larger than just that initial set of 9 cells. And I was wondering if there was any, testing or design that would, speak to that issue.
Sure. So part of what you're describing is also, a reason why a lot of these battery or lithium-ion and LFP battery systems that are out there are now often containerized and separated in enclosures. So impacts to certain enclosures don't have impacts to other ones. And generally, those thermal conditions, as shown through UL 9548 testing, aren't going to propagate beyond, especially in a unit level or enclosure to enclosure. So potentially, I would say, answering right now, I would say certainly there could be a tree falls on an enclosure, significantly damages the cells within. That could cause more thermal runaway than is shown through the standard UL 9548 testing. I think, again, the key is it can't propagate between, it has to show that it's not propagating between those modules. So even if there's more thermal runaway, you're still not showing that propagation on a system-wide scale. And furthermore, these systems nowadays are also undergoing, separate from UL 9540A, large-scale fire testing. So they're, Nick Warner from ESRG, our safety consultant who helped prepare our ERP, he spoke at the Board of Health meetings, and the ESRG themselves were present at a fire scale, or not present, they conducted a large-scale fire test of our proposed system. In that case, they don't just don't cause one cell to enter thermal runaway. They basically put jet burners into the system for one enclosure. So they're causing significantly elevated thermal runaway conditions in an entire enclosure, and they're seeing how that fire propagates or spreads. And those tests indicate that it does not propagate or spread beyond that enclosure where those conditions are created.
Okay. And if I remember the layers, we've got cells, modules, and then there's something, and then there's the containers, or does it go right to containers?
It's in terms of the UL 9548 test, cells, modules, unit level.
Okay, units,
Yeah.
okay.
So,
And units would be like a rack or something, or like a?
yeah, like a rack within an enclosure. So,
Okay.
yeah.
Then there's multiple units within
within a
the
system.
enclosure.
Yeah.
Okay.
Yeah.
And then we have we have how many enclosures in this system?
On this site, there's 30 proposed enclosures.
Okay. Oh, that's right. I remember that from okay, for this POWIN system. How do we pronounce
Powin.
that? Powin.
Powin.
Okay. Yeah.
And again, that's most LFP systems nowadays, again, are all, some will vary. I'd say Powin is the most containerized, modularized system. But again, any system that Blue Wave is working to procure or working on a site has to pass those UL, no one's going to be working with any equipment that doesn't meet those UL 9540A testing requirements. So.
Yeah. No, I was very impressed reading about Powin and their extra testing by ESRG. And it was helpful also to hear you describe it, the sort of the fire testing beyond what was required by 9450. Great, thanks.
Okay. Imogen.
Thank you. So my question is, we did hear some feedback from our fire department. I don't know if you've had a chance to see their latest email to us, but is that something that you have responses for in terms of the fire department's concerns, or something that you could get to us?
Sure. So I haven't seen the fire department responses submitted today, so I don't have those answers to those in writing. I did meet with the deputy fire chief twice over the phone between the last select board hearing and this one, and we had Nick Warner from ESRG on one of those calls as well. So I did speak with the deputy fire chief on the emergency response plan, various details that were discussed at the Board of Health meeting. Made it very clear to her that the level of training and additional information that was going to be going back and forth between the fire department and us, prior to anything close to construction, whether that's the level of training, detailed list of equipment we're going to be providing, or just financial payment to the fire department to solicit or to procure that equipment they need. So certainly the comments, once we receive those written comments that were submitted today, happy to respond to those in writing. But we have been in contact with the deputy fire chief, and we made it very clear to her that we'll be continuing to work with the fire department. We discussed the ERP which is on its second revision, third iteration. It is a draft, but it's a draft because ESRG won't finalize a version until the site is built. There's been a site visit by ESRG with the fire department. So it effectively has to remain in draft form because you're not going to finalize something before you've confirmed what's been built and what's actually out on site. So there's a lot more communication and a lot more information that's going to be shared with the fire department, and including comments like the fire extinguisher, which the Board of Health, one of their conditions was that we include a fire extinguisher on the site, and that's why we want to make sure as part of that condition it was at the fire department's approval. So, yes, we will. So happy to address that and follow up with written responses, and we're continuing to talk with the fire department.
Thank you.
Okay. Fran.
I may need my memory refreshed, but as far as noise of the warehouse and additional lighting for safety, what will that look like? And do they make noise?
Sure. So this is also extensive part of the Board of Health's discussions from an early onset. And the Board of Health made it clear that they'd be looking to DEP state regulation on sound, which is no greater than a 10 decibel increase over existing ambient levels as measured currently on site. So we did measure, we worked with a sound consultant, Epsilon Associates. So they measured sound levels on the site for a 7-day period, continuously over a 7-day period, day and night. We then take those average broadband sound levels measured on site and we compare those to what the system is expected to produce. So the system does produce noise that comes from the inverters, just like you would have with a solar project. And then additionally, depending on the cooling solution used in the system, in this case, it's air cooled, so there are fans and those produce noise as well. Epsilon takes the equipment information we have based on the amount of the equipment, the layout, they model that in the space of the current site and based on what the site conditions will be, and they assess what are those ambient sound levels going to be if you were to just install the system with no mitigation. And then that determines what kind of sound mitigation you have to have. So those modeling results we discussed with the Board of Health, and it made its way as well into a few conditions that the Board of Health issued. But basically, there will be sound. If you don't have mitigation, there will be an increase over ambient. The required mitigation effectively dictates a requirement for 12 feet of noise barrier effectively on the site on the east, west, and southern sides, to put it more simply. Because of the grading we're doing with the retaining wall, it's expected that most of the sound mitigation will be provided by that grading, and then any additional sound mitigation required to meet that 12 feet of barrier effectively will be installed on the site as well. So the Board of Health also required that we update that study prior to construction as well as after construction, measure the site, make sure we're in compliance, and if not, we have to provide more mitigation. So that's an overview of the sound analysis. From a lighting perspective, we don't necessarily have a requirement for lighting at night. We were deferring to either the Board of Health or the Select Board on that. There was a request as part of the Board of Health that, we have some kind of outdoor lighting at night, motion detected, and I believe in the request that made its way in our condition is just that those aren't facing the southern border or southern property boundary, so they're not disturbing neighbors. And of course, any lighting proposed on the plans before construction would be approved to meet the lighting design criteria in the bylaw.
Other comments questions from the Select Board? Okay, thank you very much. Since we have counsel here, I would like to have counsel elaborate just a bit on the potential import of the recent Wendell decision and also deal with the question 1985 subdivision, since that was brought up by the applicant.
Sure. Thank you. Christina Marshall again, Anderson and Krieger. The recent AG's decision more or less confirms what the zoning board has already found with respect to this, use, that it's a permitted use in this district. Is also protected by the Dover Amendment, which also limits the extent to which the town can prohibit the use. And the subdivision plan issue, we're generally in agreement with the analysis of that issue as submitted by Attorney Hewer. It goes a little bit beyond the scope of the subdivision control law to limit uses within a subdivision. If you were inclined to include a condition in any approval, requiring that the planning board weigh in on that issue, you could do that. But generally speaking, we don't think that's an appropriate limitation on the use.
Thank you.
Thank you.
John, do you have anything you'd like to add?
I do not. The planning department could comment on anything that they received today if that's of interest, or we could just be available to answer questions.
Well, why don't you open up to the questions from the public? I'd like to keep this fairly brief. We've had extensive amounts of email sent to us, and certainly I've read every one of them. I'm sure all of my colleagues have as well. We've got a fairly limited number of questions that we've reopened tonight, and I'd like, if anybody wishes to comment, I hope that you can confine your comments within the bounds of what new information we brought forward. So that is, and also, I would like to keep individual comments down to 2 minutes, because we do have a pretty good sized crowd here. So if anyone has any questions or comments they'd like to make, please come forward.
Hi, this is Terrified Skin. I forgot to bring a printed copy of Rachel's letter. Is anybody going to read Rachel's letter here to put that in the record? I know they send it via email, but often people don't read it. I'd be happy to read it. With respect to the comments and the questions, the applicant and the questions seem to be focusing on mitigation of dangers. The more they talk, the more I'm nervous. And we're failing to address the onus that the applicant has to convince you that it actually benefits the community. So it's not just mitigating the dangers, it's actually benefiting the town. So, and the neighbors and the neighborhood. Relative to the ZBA and the Board of Health, those boards have very, like a sliver of responsibility to determine measurements and uses and other types of things. You're supposed to determine something else, whether or not it harms the neighborhood, whether or not this benefits the town overall. And the onus on you guys for your vote is only to prove that you believe something. So according to the Attorney General on these special permits, there's a reason why it's a special permit. It's above and beyond all the other stuff. So when the courts decide whether or not your vote is valid, for example, all you have to do is decide that you believe that it shouldn't go there. And that's enough. So you don't have to prove that you had a valid justification. You only have to prove that, yes, in fact, you did vote to deny it. The second thing is relative to trees. Just because they have a clearing area and a map, which they never gave to you that I could tell, once that operating permit is given, they can take down all the trees they want to, because there is no limit on tree clearing in Acton at the moment. So secondly, these folks talk about safety, but they don't seem to be willing to put their personal houses and lives online. They're hiding behind an incorporation, which prevents, or limits their liability. If there is no liability and it is perfectly safe, then have them step up and sign up for all the liability for the period. I'm almost done.
Got about 10 seconds.
10 seconds. And so in Wendell is not applicable, apparently. If you'll read Rachel's part, somebody read it. I believe, I'm convinced that it's not applicable. And so I believe that you have the right to say no. I hope you do, because all you have to do is say that you believe it's not good for the neighborhood. Thank you.
Thank you. Other comments?
Yeah, Bill Clower, Piper Road. Has anything been brought up about the size of the fire department here in Acton and what their abilities are compared to what this event would require, besides adding onto that the evacuation of the building? I think it's called Middlesex Gastronomical Unit or something, which has, I understand, people that are impaired that are going in, having colonoscopies and stuff like that. So I'm not too sure. The last I knew, we have 4 stations now with 2 men in each station, and 2 personnel in each station. And I don't know quite what their abilities are when it comes to something of this magnitude. So I hope that you'll consider this in your...
Okay. Please.
What we have submitted up from the last select board hearing up until today, like what we emailed, will that be part of the public record, or do I have to read out loud emails?
Everything that you have submitted officially to the town is part of the public record.
Even if it was after the last select board hearing and up till today?
We've been receiving things
Okay.
continuously.
And okay. So if you're going to include in part of the record, then I am happy. I don't need to repeat things I've already said in writing.
Thank you.
There's one person online.
Okay, Matt, can you let the online speaker in?
Certainly. Charlie Cudlick. Charlie, you should be able to speak.
Yes, this is Charlie Cudlick at Paul Revere Road. The comments from the deputy fire chief that town manager read earlier indicate that there's equipment that the fire department will need which it doesn't have, personnel issues which are unknown but likely to be substantial. Is there any estimate of the additional cost of all of this fire department and other department needs related to this project? And is there any revenue that's going to come from this project?
Okay, thank you, Charlie. I'll try to get you those answers. John, would you care to address the issue about, has the assessing department investigated any revenue prospects for this project?
No, I think that the assessor's office was, is aware of the project. Typically, these would have a pilot agreement, which would create, which would be a way to identify a revenue amount in lieu of just fluctuating with property tax rates every year. So that we haven't sorted that out yet because we didn't want to do that proactively. But in terms of, right, so there would be revenue associated with it. What amount, we haven't determined that yet.
Thank you. And my understanding from the letter you read from the deputy fire chief, I understand there is going to be some funding forthcoming from the project specifically for fire department equipment.
I don't know that to be the case, but I'm happy to be corrected by planning staff. I think the deputy was just referring to the need for 4 training sessions, which I assume that the applicant would provide. I'm not aware of equipment being purchased, but that's something we could discuss if it's needed.
Okay, thank you. Other comments from the public?
Angela Morrison, 15 Brucewood Road. Sorry, I like to type out my responses first. So to bring up the trees again, there are some trees that are more than hundreds of feet tall. So what happens if that tree that could potentially fall on the battery component be on one of my neighbor's lands that abuts the property? Are they going to be allowed to take down that tree if it could potentially fall on it? The other thing, when Jim brought it up, if it falls, it goes this way horizontally instead of vertically and up and down. So if a tree falls on the entire container, then it's going to spread throughout the entire container, not just, one row if there's multiple rows. So I just wanted to bring that up. And then given that our fire department's so small, have you guys talked to neighboring towns about the impact that it might have on them if they need to come and assist with our town's fires? I don't know if they all talk or not. I know up in Townsend they do. I don't know if they do down here. And then I just want to remind you guys that you guys are elected officials and you're in those seats because people voted for you because they trusted you to protect the town's resources, the habitats, the people, and the public officials. And there's a reason that the Board of Health has the longest list of contingencies for this project. I think it's not safe near this residential community. This project is closer than to what the Weymouth project was, and Weymouth denied it. So I think follow suit of other towns and deny the project. Thank you.
Thank you.
Mr. Chair, I just wanted to, if I could, the question of equipment, the deputy fire chief mentioned that we do not have an HF gas meter, which is something that the board could ask or require be purchased. I don't know what that is, so I don't know what kind of ask that is. We could certainly look at that if that's something that remains a concern. And I would also just mention that our fire department is staffed to provide services to our community. And like all the other communities, we rely heavily on mutual aid to help support each other. Earlier this week, we were in Concord, and other communities come here when we have incidents. So we could always use more staffing in every department, but our fire department has a good teamwork approach with other communities that allows us to work together to respond to big incidents and small incidents as needed.
Okay, thank you. Well, I think we've entered into the record the new information. I think at this point, I'd like to see if the board is willing to close the hearing once again, and then we can discuss after that whether we're going to deliberate now or push this off to later. Anyone? David?
I'll move to close the hearing.
Second.
Okay, moved and seconded to close the hearing. Jim?
Are we, when a hearing is closed, can we still get guidance from town council if they're present? I guess that's
We have counsel right here to answer that.
I'm just, okay, oh yeah. That's very recursive. Go for it.
Yes, we can return if you all push off the deliberations till another date, and we'll be here to provide advice as needed.
Thank you. Thank you. All right, it's been moved and seconded to close the hearing. Site plan special permit 713-2022-488, 100 Discovery Way. All in favor of closing the hearing, please say aye. Aye. Opposed? Abstentions? Okay, we're closed. Thank you. So, I'll ask my colleagues on the board, what is your, we've read a draft decision that was prepared by planning staff that shows either granted or denied, depending upon the decision of the board. We have received quite a bit of information in our packet and even till tonight. What's the desire of the board? I believe we have a period of time before we have to make this decision. David?
So, depending on what you want, Mr. Chair, there are, I don't know, maybe about 10 different areas in this decision that, we have to choose one path or the other. I could go through those one at a time. I don't know if we're ready to do that now, though, or whether we want to, move forward with making a decision. The ones that are really the meat of the decision are 2.16, 2.17, 2.21, and 2.22. The rest of them are either less important or for the decision, or there are different reasons to answer them another way. But the 2.16, 17, 21, and 22 are really the meat of the decision. And I think after we answer those, then we'll kind of know the answer to the whole thing.
Okay, well, we should start to deliberate.
Would you like me to go through one at a time, or?
Yeah, that would be a good start.
Oh, sorry. Yes. Okay, so if I start with 2.7, this one and the next one, I would suggest that we do the text in green, which is the board finds an additional 160-foot buffer, existing tree coverage, and additional proposed vegetation screening meets the requirements of the landscape buffer. And it's just, there's a similar thing down below in 2.13. And the reason for that is the other way, so the requirement in normal zoning is to have a 10-foot green buffer around a parking area. This violates that now. If, depending on how the decision goes to the end, and if let's say we deny it, and if the applicant appeals to Superior Court, and we're enforcing this rule, then they have to move it back to their original location, which cuts down half the woods. So I would suggest that we do the green answer here, regardless of whether we approve or deny the thing overall. And similarly, in 2.13, I would suggest that we say meets the requirement of section 6.7.9.2.
Okay.
Any objections to that? Um, 2.16, we just need to say whether this is consistent or not with the master plan, and if not, where not. I don't know if people have comments whether they think this is not consistent with the master plan.
Ibenja.
Yeah, thank you. I think for me, this is the big thing where I am currently not convinced that this plan is in compliance with their master plan, specifically regarding the goal of environmental sustainability, regarding our ability to ensure the future health and well-being of our environment. I think that especially given the fire department's letter today, I'm not convinced that the current health and safety plan that the fire department has had reviewed, that was submitted to them by Blue Wave, is enough to essentially say that this plan would not harm our environment, or if there was an adverse effect and there was a fire, that we would be equipped to deal with that in a way that doesn't harm our residents, but also doesn't harm our environment, given that this is a wooded area. So that would be my big concern.
Any other comments? Jim?
Yeah, I haven't completed my look through the goals and objectives of Acton 2020, although, of course I should have them memorized, but, you can only do what you can do. So I agree with Image's points there, but I would like some more time to look at some of the other points to see if they apply as well.
David?
Yes, so I think this facility furthers our sustainability goals. There's a strong need for additional electrical grid infrastructure in town. We can't pick and choose which ones we want. We have to find, apply the rules consistently. If we denied this special permit and that stuck, then, I fear that we would not be able to permit any in the future, right? There is actually, this facility is more than 250 feet from any residence. It is very difficult to find any place in Acton that is more than 150 feet from any residence, right? This is one of the few places in town that is more than 250 feet from any residence. And, you know, there is limited, I think, ability on our part to deny this. This is allowed by right in this location. It's one of the best locations in town. And we have two other facilities running in town, one other facility already permitted to run in town. To say this one all of a sudden pushes the fire department over the brink, that they can't handle this facility, but they can handle the other three, it doesn't make any sense to me, right? The Board of Health already put many more conditions on this facility than any other facility. Well, you know, the other facilities, at least the two of the other facilities were public entities and not subject to special permit in the locations that they were and because they were public entities. But they were subject to Board of Health, which actually put fewer conditions on those facilities. So I think not only does it further sustainability goals moving forward, but I think that we're hard pressed to deny this on the basis of the master plan.
Okay, thank you. David, why don't you work your way through?
Okay, the next is 2.17, where the plan protects or does not protect the neighborhood and the town against serious, detrimental, or offensive uses of the site against adverse effects on the natural environment. This is a little bit similar to the last one because what Himager brought out was, from the master plan, was sustainability and environmental issues. So this is pretty similar, but at the neighborhood level.
Okay. And Jim?
I wonder if this might be a good time to get some, would this be an okay time for me to ask council some questions about this direction?
Absolutely.
Okay. So let's see. We're looking at a site plan special permit as opposed to a use permit. And I know I always get confused about the difference between the two. What I remember is that, we require a special review of these, and that we're in some way, there's always been some confusion about our grounds for being able to deny special permits. So I guess my questions would be along the lines of, how do we use these concerns about health and safety and in the environment to deny a site plan special permit if that's the direction we want to go to? What's the way to write that in a way that is likely to stand up to scrutiny?
So, site plan special permits are a very different animal from a typical special permit, because special permits are uses that are not otherwise permitted under the zoning bylaw, and the special permit granting authority needs to make the determination that it is, advantageous for the town to grant that use. Site plan special permits are different because they, and especially as applied here, apply to otherwise permitted uses. So this use is permitted as of right. So the board cannot prohibit this use in this area. The site plan special permit review is really limited to imposing reasonable terms and conditions to assure protection of the public interest. I'm reading from an SJC case there, for that use. So the board's discretion is to impose conditions under the bylaw to approve the site plan in accordance with the criteria of the bylaw. It is very difficult to deny a site plan special permit unless essentially the applicant has completely failed to include information in their submission that could result in a reasonable condition applied on the project. I hope that helps.
Yeah, so what I hear you saying is that we can apply conditions.
Yes.
And that for those of us that are interested in slowing down, preventing, or changing this project, we should choose conditions that help achieve that end.
I think the extent of the board's power in this circumstance under the case law on site plan special reviews is that you're limited to imposing conditions here. Yes.
Mm-hmm. Thank you.
Any other questions of council while she's up here? Nope. Oh, Imogen, please.
Sorry, yes. So if we were to say, for example, for any of these articles, like 2.16, 2.17, that the plan is not consistent with X, Y, and Z, that's not grounds for us denying a permit, or?
That's correct. You'd have to go a step further, and just the mere non-compliance with one of the criteria wouldn't be sufficient. The court would look to whether or not there was a condition that you could impose to kind of go towards that compliance that you're looking for.
Okay, thank you.
Thank you. Imogen, Fran.
Where would safety play in? Just creating condition based on safety?
Yeah, you
Yeah.
could create any sort of conditions based on safety, require compliance with the Board of Health regulations, or, requiring further discussion with the fire department, You could certainly have conditions geared towards safety here.
Okay, thank you.
Okay, thank you.
David, back to you.
Thank you. 2.18, it talks about safe vehicular and pedestrian movement. I think that's really not an issue at this location unless someone on the board disagrees, and I would say that the plan does provide for that. Is that anybody? Jim?
Well, when I think about emergency vehicles, I do think about the very long access to 100 Discovery Way. You sort of come into them, you come off of Piper Road, and then you have to take this sharp left turn and go all the way around. This is the kind of driveway that wouldn't even be legal anymore, because it's an overly long access. It was legal at the time it was put in. I'm not suggesting there's anything illegal about it now, but it does create a challenge for rapid, safe access, or for rapid, safe exit for people that are exiting. So I have some concern about that.
Yeah, I'd respond to that. The access is essentially flat, not a lot of hills to worry about. Good turning radii all around the building or on the site. At least along the access roadway, there's not a large number of trees that are likely to fall over and block the road. So I think at least to that instance, I think probably does provide decent access. Also, one of the conditions in the past that the planning board puts on these things, especially limiting the length of cul-de-sac roads, is to make sure that there's proper fire protection, and there is going to be there's going to be a fire hydrant quite adjacent to this. It's not like they're going to pull 1,000 feet of hose in all the way from Piper Road. So I think that sort of mitigates that to a certain extent.
So I don't know, Jim, you're the one who spoke against, or are we in agreement with the plan providing safe vehicular and pedestrian traffic, or are we still not able to decide?
I'm happy at some point to have this go to a vote, I can be outvoted. It's not a big deal. It's my opinion that it doesn't, that there's a concern there, but I may be in a minority.
Well, why don't we vote this one anyway? As far as section 2.18, I have someone move that to state that it provides convenient and safe access.
So moved.
Have a second on that? I'll second. Discussion? Call for a vote. As far as section 2.18, motion, seconded motion is that the plan provides for convenient and safe vehicular access. All in favor of that motion say aye.
Aye.
Aye. Opposed?
Nay.
Abstentions?
I'll abstain.
So that fails.
Fail.
So that means we're saying that it does not provide, and so we need reasons for that?
Yeah, if we were to write reasons, I think I would focus on the emergency vehicle access. I agree that normal vehicular and pedestrian traffic is, getting in and out of there okay.
And specifically, Jimmy, you sounded like you were concerned about the emergency vehicles where after they pull in, there they have to take a left and a right? And that's really the, other than that, it's pretty straight, right?
Yeah, it's more of a distance and time issue.
So I'm sorry, I'm just going to play, Mr. Chair, if I may.
Sure.
I'm just going to play devil's advocate. Do you know that this is, takes more time for a fire truck to get to than the other facilities in town? Right, I mean, if you're just saying it's distance and time, right, this could be responded to by South Acton or Acton Center, or West Acton for that matter. Do you know that, compared to the Grace property, that it takes longer to get here?
No, my guess is that it would be quicker to get to the schools, both the current one and the battery system that's installed, but that WR Grace would take longer to get to because of its location.
So, I don't know, we're going to have concrete reasons to put here.
I'd also observe that when you get to the fire department responding to the existing one at the high school, has to deal with, talk about vehicular access, has to deal with a couple of hundred parked cars around it. And frankly, living in the neighborhood, Haywood Road's not that great as far as traffic access. And I expect once the new one is installed at the Gates Douglas School, it'd be the same situation, dealing with the large numbers of cars parked directly adjacent to this facility. So you feel that this would be harder to respond to than the ones at the high school and the elementary school?
That's my impression, but I'm no expert. We could perhaps take some time to ask the fire chief to weigh in, or the deputy fire chief to weigh in. I'd be happy to defer to their opinion.
I'd be happy to follow up with the deputy
Yeah,
fire
well, I
chief.
was just going to ask John if any of the discussions that you're aware of that the fire department's had with the applicant and planning staff, has this been raised as an issue? I don't recall seeing it in any of the official memos.
I would defer to Kristen on anything other than I have here before you, but what I have is just the memo or the email I got from the deputy fire chief this afternoon in terms of discussions about this project. Kristen?
We have not received any concerns from the fire department in that regard at this time.
So I think your question has been answered, Jim. In light of that information, should we reconsider the vote?
Well, since I'm operating from a place of ignorance, I'd be happy to change my vote to abstain. That would effectively make it go from fail to succeed, right? Because it would be two
Yes.
abstains, one no, two yeses.
Okay, so as far as 2.18,
Excuse me, Mr. Chair. I apologize. It's Kristen Bouchard, Planning Director. Given that the town of Acton has a site plan special permit, the voting threshold for special permits requires a supermajority, so 3 would need to vote in favor.
okay?
So here, she's absolutely right, but I think we can figure out any way we want to construct the thing that, in the way the board wants. I don't know how we want to do that. We can vote on everything and require 3 or 4. But the assembly of the thing is different than voting on the thing at the end.
Yeah, I think that's a good point. I think, that I would be comfortable with saying as far as 2.18 plan provides. And then, we can always vote on the entire, we will be voting on the entire decision, if you're happy with it or not. Go ahead, David.
So I thought the last one would be easy. But 2.19 provides for adequate parking and loading spaces. I don't think this facility requires any parking spaces except for a service, so I was thinking that it provides, if people agree.
I'll agree with that.
Any objection, Jim?
Just a question. So the parking that's right next to the facility now, those spots, those aren't reserved for the facility, so they're general parking spots for the entire site. Would there be conditions? Do we need to do something to make sure that there are spaces available on certain times? Construction, delivery, maintenance. Maybe that's being handled with an agreement with the owner. But it could be that we might need a finding that the owner should make, the owner should work with the applicant to make sure that there are spaces available as needed. It would be a shame to have the big truck show up and, have no place to park.
I'm also running a list of possible conditions that we could talk about at the end.
Yep.
Can I add that one there?
Yes, please.
Okay, but other than that, we're okay with that being provides. The plan provides or does not provide adequate disposal of refuse or other waste resulting from the permitted uses. After construction, I'm not aware of any waste. But we could put a condition that all waste be removed from the site or something.
I might suggest that we cite the Board of Health permit.
Okay, and then say it provides.
Yep.
So 2.21, I figured would be more of a point of discussion. The plan will or will not derogate from the intent of this bylaw to limit the adverse effects of the use and development of the land on the surface and the groundwater resources of the town of Acton.
Jim.
I think the analysis that they've done under the chapters that require that, analyze the runoff looks sufficient to me. I think they're protecting the local water there. So that's not something I would fight for.
Thank you. I think we'll go with the will not under 2.21.
Okay, and 2.22, the plan complies or does not comply with all applicable requirements of this bylaw. I think that it does, except for the 2.16 and 2.17 above that we haven't determined yet.
Jim?
And there's also a specific waiver they needed, a couple of them, right? One was one was the screening, and the other was something associated with the piping out to the main power source. And then we also have to decide about the sidewalks. I'm not sure if this is the place to mention that, but since they are asking for some specific waivers, it seems like it would be not quite correct to say that they're meeting all the applicable requirements of this bylaw.
Should this say, except where noted in this decision?
Yep.
So the other things, Mr. Chair, are just the list of conditions, really starting on 3.3. Do you want me to read those one at a time?
Yeah, let's go through those.
Okay, 3.3.1 is the site plan is subject to compliance with the Health Department's hazardous materials permit issued on March 7th, 2023. Any problems? So maybe I'll ask to see if someone wants to hold. 3.3.2, all outdoor luminaries to be LED and not to exceed a color rating of 3000 K with proper shielding and or additional shielding as may be required, all in compliance with the bylaw, section 10.6. Any holds? 3.3.3, all construction activities and continued operations after completion of the facility shall be conducted in compliance with the requirements of the bylaw and the Town of Acton general bylaws, including chapters X and U. 3.3.4, in exercising the site plan special permit, the applicant shall comply with all requirements for water service installations, operations, and maintenance of the water supply district of Acton. Okay, 3.3.5, the applicant shall be diligent in complying with the erosion and sediment control plan. The applicant shall not cause or permit runoff of water or erosion that will result in flooding or a situation of any street, way, or drainage facility owned or maintained by the town. If such runoff or erosion occurs, the building commissioner may order the immediate cessation of any excavation, construction, and building activities until the conditions that caused the runoff or erosion have been corrected. 3.3.6, the applicant shall be diligent to ensure that no construction debris leaves the site. 3.3.7, all construction activities on the property relating to the site plan special permit, including demolition, shall be limited to the hours of Monday through Friday, 7 a.m. to 6 p.m., Saturday, 8 a.m. to 5 p.m., and Sundays and holidays, no work permitted.
Just a question.
Jim?
Are those hours, does that come from some particular bylaw, or is that our habit, or I'm just wondering how those particular hours came to be, if maybe someone on the planning department would know.
Kristen raised her hand.
Hi there. Yes, that's a standard condition that we typically recommend for all site plans. In the past, the select board has approved those specific hours dating back, I'd say, at least 12 years.
Thank you.
Okay, 3.3.8, the applicant shall be diligent to ensure that trash and debris be properly managed on the site at all times. 3.3.9, ensure that all pay on the property shall remain paid in full, including any penalties and back charges resulting from the non-payment of any non-payment of taxes, if any. 3.3.10, all work on the site shall be conducted in accordance with the terms of this special permit and shall conform with and be limited to the improvement shown on the plan as conditioned, modified, and improved herein. 3.3.11, at the conclusion of construction and before the issuance of any occupancy permit, the applicant shall submit an as-built plan, including the certification form required per the rules and regulations of under the town bylaws, Chapter X. The as-built plan shall be, 1, stamped and certified by a Massachusetts registered professional land surveyor showing the accurate locations of the buildings, pavement, drainage, utilities, and other site improvement, and 2, stamped with a Massachusetts registered professional engineer to certify that the site has been completed in accordance with the approved plan pursuant to this decision, and all features required on the site by the approved plan and other governmental entities with jurisdiction as applicable have been field inspected by the PE, and the systems as built perform as expected from the approved design. Any non-conforming features shall be clearly noted with explanations for the discrepancies in functionality. 3.3.12, the decision shall be recorded at the Middlesex South District of Deeds Land Court prior to the issuance of any building permit for the new construction or any certificate of occupancy. And 3.3.13, work on the site shall be conducted in accordance with the terms of this plan, a special permit, and shall conform and be limited to the improvements shown on the plan as conditions modified and approved herein. And then, Mr. Chair, based on notes I took during the thing, I have 3 possible additions. And maybe I could just list them briefly now and then work on the language after the meeting. Or we could wordsmith language now if we want. The first is to build, that the fire department would be supplied with a hydrogen fluoride gas meter. And second would be any vehicle parking required by the site be so designated. And finally, a contribution to the sidewalk fund, as is our normal practice. In lieu of building a local sidewalk. So usually the requirement is that developers build a sidewalk, and if they're not building a sidewalk, that they contribute the equivalent amount of money to, if the sidewalk would be a sidewalk to nowhere, to contribute an equivalent amount of money to the sidewalk fund. Yep, very good. So any objections with those 3 things? And is there any that I missed?
Imogen.
I think that list looks good with just a slight modification for the first one. So not only, I think that for me, I would like to see that be expanded, providing the fire department with the HF monitoring equipment, but also any resources that they need for adequate training, whether that be, providing that training personnel or the funding to be able to access those types of trainings, and also to fund any additional materials needed for the fire department to feel like it can adequately respond to a fire in case there is one. And then, can I add one more thing? And then, sure. This is actually more of a question, but in the case that there is in the worst case scenario that there is a fire or something happens, I wonder if we can put in a requirement that in the case that there is an adverse happening that happens, that we have the chance to review the terms of this special permit again and reassess whether we want to continue to allow Blue Wave to remain on the property or not, and also whether they would be required to fund any remediation efforts if needed. I don't know if that's legally possible, but something I would want to see.
I would defer to council on that.
So this is not something that I have thought about before, so can you just repeat what the proposed condition is, and I can try to talk it through?
Yeah, absolutely. So say, for example, there is, like, worst case scenario, there is a fire that happens. If there's a way for the select board to review the terms and conditions of us permitting this special permit, and to see whether we make a decision to vacate Blue Wave from the property and require remediation efforts for damages that might have been caused because of this facility. Is that legally something we can put into this?
So I think on the first question, which is whether or not you can kind of have them come back to you to reconsider the terms of the approval, I would recommend kind of framing that again in that conditions language to say, you know, come back, and if there are, you know, so we can consider if there are different conditions that we can impose on this site plan special permit to address these concerns or these issues that have come up. And again, going back to that case law, like if it turns out that there are no conditions that you can impose, then there is potentially a narrow avenue to rescind the permit at that point. But I would stick with the conditions now. And on the second point, that is something that I might just want to look into a little bit more. It strikes me as a little bit, it strikes me as okay. That's my first instinct, but like I said, I haven't thought about that specific idea before, so I wouldn't want to rest on that for now.
Thank you, that's really helpful.
Okay,
Thank you. David?
So there are other places, I think I'd have to read through this again, but that say that operations will cease if. So maybe we can put something in that, similar to that. There's operations will cease until, you know, I forget what thing caused those, but it could be that if there is an anomalous incident, even if it's not resulting in a fire, that operations will cease until something, maybe till the health department says something. I'd have to look through. There is wording here, I believe, somewhere for that. And the training and materials for firefighting, I think the training is covered in the Board of Health decision, but I'm 99% certain that that's the case. But I don't think that I remember reading anything about, you know, materials, you know, so maybe we could investigate that a little bit.
Okay, thank you. I think at this point, you know, the main sticking point seems to be the debate that we had very early on about whether this is or is not consistent with the master plan, and everybody, master plan is great because there's sufficient material in there to support whatever point of view you have. So I think as a board, we're going to have to decide, you know, whether it does or it doesn't. Does anybody care to elaborate? Jim?
If I'm internalizing what I've heard from town council correctly, a denial of a site plan special permit just by talking about master plan adherence is going to get swept aside pretty early. So, I mean, it might be fine as a delay tactic because it requires, you know, going out to court and all that, but it doesn't seem to me to have a lot of power in this case. That sort of thing has more power on a use permit. For me, so I'm more focused on conditions. So I had some additional conditions and maybe some comments on images conditions.
Okay. Well, why don't you proceed, Jim?
Imogen, I was trying to, come up with some conditions that made sense, and I think you've captured one of the key ones, which is the, that just as the Board of Health is reviewing its hazardous waste materials permit every year, they already have that built in, it's really good for us to have an ability to, reconsider and/or, add extra conditions or, and/or, get money back to make damages whole. The other concern that's been sitting with me is the one about the how the applicant, the timing for the applicant to respond to the situation. So I was thinking of a condition, some kind of two-part condition about requiring, a telephone response to the fire department within 5 minutes or 10 minutes right away, and then a requirement to be on site, as if requested by the fire department, within 30 minutes. I think the quick response by phone is going to at least get us to the point of, quickly reaffirming what are the right actions, like don't open the door or don't start dumping a whole bunch of water on the units, concentrate on, dampening the ground around the units so that, if there is a spark or a fire, it doesn't spread or, whatever makes sense. That'll all be written down in the emergency response plan, but it's just so much quicker and better to have that said directly by a human being who's responsible for the site, very quickly. That would add to me a much better sense of that, oh yeah, we can handle this, to have those kind of quick response times.
30 minutes is a long time.
Well, I'd take whatever short time the board would be willing to live with. I thought my guess was 30 minutes would be enough, but to me, the quick one is the immediate response by phone. Someone has to be prepared to be woken up and answer the phone quickly.
I'll agree with Jim, certainly, on the 10-minute phone call response. It would seem like this is something they should be able to easily respond to, having spent most of my career being on call 24/7 and always having going way back, a pager on me. So I think the 10 minutes, as far as the in-person response, I think 30 minutes is probably, and they could agree to it, but I don't think it's a practical condition, because you just think about traffic situations. Say if the folks are, if they've got an office in Waltham and it's 4 o'clock in the afternoon in commuting time, getting to the site in 30 minutes is probably not a reliable expectation. I think a 1 hour in-person response time, especially since they'll be communicating and providing information for the fire department anyway, within that 10 minutes. I think that's a more defensible time span, I think, than 30 minutes. If you want to make it a quicker response time, you're basically going to say that the responder has to be basically living geographically within the town of Acton. I mean, that's how long it takes. It takes you more than 10 minutes to get from North Acton to South Acton.
I was considering that sort of condition, but I didn't think I'd be able to get it by the board.
Yeah. David.
So I just want to emphasize here that if there's an actual fire or other emergency, the fire department does not need to wait for this person, right? So if there's an anomalous condition, Blue Wave is notified electronically from the unit. They call the fire department right away. The fire department goes out, and the person starts coming. If the fire department sees something that is dangerous, the fire department can deal with it before anybody gets there. They don't have to sit there and watch the thing burn. They'll already be trained, and they can do what they, whatever the fire chief or whoever's on, who's ever the senior firefighter on staff, in directing the response, thinks is the right thing to do.
Let's look at the emergency response plan, because there's language in there about how certain things the fire department isn't allowed to do until there's a person on site. So I wanted to make that window be as small as possible. Yeah.
All right, Jim, do you have other conditions you're suggesting, or is that it?
No, I'll note that, 5 seconds of detailed research says that HF gas meters are not unreasonably expensive, so I'm very comfortable with that position. The other one I was thinking about was, I think that the plan itself and the application doesn't specify the manufacturer of the, of the actual units will be this Powen company. It's certainly part of the narrative, but it doesn't seem to be part of our conditions, and it doesn't seem to be on the site plan. So since I understand this one company, and I would prefer that we specify that manufacturer will, be used. I'm not sure the right way to say that, but I don't want them to, substitute an unknown or a different manufacturer at the last minute who we haven't, seen the tests for. So that's the only other condition I was thinking of.
So in response to that, I think there's been considerable discussion about NFPA standards, UL standards that are required for all of this equipment. And I'd be much more comfortable requiring and citing specifically that the equipment shall meet these standards, rather than coming up with the name of a specific manufacturer in case, company goes out of business or realizes they're the only game in town and they jack the price up or whatever.
I get that. So the 9450A test is not a pass or fail test. It does a series of measurements and tests, and then provides that information. So if both the Board of Health and the Select Board can review the results of the 9450A, if the manufacturer changes, if it becomes different than the 9450A results that we've seen, then that would also satisfy my concern.
Okay. I would suspect that what's going to happen, I'd like to take a vote on this tonight and decide which way we're going with it, and then, as is our usual practice, we'd have planning staff would work with certainly the applicant, fire department, other experts to fine-tune the conditions that we're discussing. That's our usual practice. I guess the question is everybody content with the that we satisfied sections 2.16 through 2.22, that it does protect the environment and provides parking and what have you within the conditions that we've laid out?
Yeah. As we were discussing these points, it seems like we added some refinement language to some of these conditions, but basically, yeah. As long as that the notes of our discussion get incorporated, I'm fine with it.
I suspect that planning staff is going to be watching the tapes of this meeting repeatedly. Mr. David.
I just wanted to say, the only change to the text that I have is in 2.2.1, prefixed with except where noted in this agreement, this decision. And then I have 7 new conditions.
Okay, why don't we, just to refresh our memory, David, why don't you, Imogen.
So sorry. Just to Jim's point, with having the review annually potentially, or like a periodic review of the terms and conditions of the site permit, I'm wondering if we can also concurrently try to do that with the Board of Health so that we can also monitor what their assessment for the adherence to these terms and conditions are. So that's the only thing I would add, is make it concurrent with the Board of Health.
That seems reasonable to me. David, do you want to read through those 7 conditions, just to refresh our memories?
Yes, and I'm thinking, Mr. Chair, that we might want to just take a, well, we could take the final vote tonight, but I thinking we might want to take a intended vote, if you will, you know, a sense of the, I mean, other you know, boards in town do this. They get a sense of the board, and then I can work with planning, and I know one of these is going to involve input from council, and so to come up with the final wording. The 7 things that I have now are the hydrogen fluoride gas meter, the designated vehicle parking for the facility, sidewalk fund in lieu of sidewalk, materials for the firefighting, or equipment, maybe that's a better word or something. Operations must cease pending a review after an anomaly. Telephone response in 5 minutes after an anomaly, someone on site in an hour, and maybe look into the ERP window a little bit as to what things, what situations that the fire department can do, the things you mentioned, Jim. And then finally specifying the facilities of the, or the requirements for the battery units themselves, either by UL tests. I think I'd like to specify the battery chemistry, because battery chemistry being used now is safer than other battery chemistries. And so, but we do need to figure out the exact wording of that.
Okay, I think that's reasonable. Imogen.
Sorry, I keep heading in. Just one small amendment to that, with the pending review, if there is an anomaly that happens, and operations ceasing. Also, if we could add in some language of, if the board decides that there needs to be an investment for any remediation efforts, that decision could be made with that review.
Or the board, or whatever body is the judgmental body, like if it's the Board of Health.
Precisely.
Right.
Jim.
Just to go a little, I'm very comfortable with this general sense, you know, in terms of us giving direction to the planning board for drafting a decision for us to look at. The sidewalk fund, I think, I seem to recall there was some dispute about where a sidewalk would be and whether there was already a sidewalk, and so how to measure what the you know, appropriate contribution would be. I wondered if maybe Kristen or someone from planning would remember that or have any feedback on that.
Hey there. I'm going to take a look back in our comments, because this goes quite a ways back. The frontage for this particular site is a little bit unique in that the subdivision portion that provides the frontage is really something that you don't visually see, right? It's something that is on the ground on a plan, it's delineated on the ground with property lines, but it's really that bulb, like that turnaround that you see on the original site subdivision plan. So I just need a moment to take a quick look at our initial comments that we had submitted in that regard. So just give me one moment.
Can I ask another question while we're waiting?
Sure.
David or Kristen or anyone, it seemed like there was also another variance that they needed to go forward with this. And do we have that reflected in our draft decision already?
I think you may be referring to a waiver.
Yes.
So the waiver is reflected in the draft decision. So that particular waiver was discussed, I think, earlier by the board. This has to do with the perimeter landscape buffer around the existing parking lot.
Right.
So that's through the flexible parking plan. So you're basically saying we are preferring the most current plan that's been submitted, and we believe making those findings that were kind of noted up above, that the greater setback from the abutters is more advantageous for the site. It better protects the neighbors, including abutting residential properties, more conservative in its use of natural resources. So we would be making those findings up above if you were in agreement with the waiver that is listed.
Thank you. Yeah, Dina's helpfully pointed out the part of the draft decision that has this in it. Thank you.
Okay, so the total frontage for the property is 853 feet according to the site plan. And then if we take our standard that we typically require for a payment in lieu, if the applicant is interested in offering a donation, rather than constructing a sidewalk along the frontage, it would be based off of, I believe it's the 50, let me just double check one moment.
Uh,
50 feet per linear foot of sidewalk. So I think in this particular instance, the board would want to make the determination that it would not really be necessary. The one thing I should note is that there is an existing sidewalk that brings you all the way up to the site along Discovery Way. There's really, there's a second, obviously the other side of Discovery Way that does not have a sidewalk. So the board could think about that. But there is an existing sidewalk on one side of the road, leading all the way up to the site.
Okay, thank you. So, I think at this point, we've talked about conditions. We realize we're going to have to take a step back and have David work with planning staff to flesh out some of the points that we've raised. I would entertain a motion to vote this contingent upon, final approval at a subsequent meeting. If anybody would care to make that motion. Imogen,
Can I make a comment?
certainly.
Maybe, well, for me, I think that hearing what planning staff and what David comes back with the final draft for in terms of the language for conditions, I think that would be important for me to see, as well as what Blue Wave can submit in terms of their conversations with the fire department, given their letter to us today. So maybe it makes sense to postpone the decision, but we'll defer to the board on that.
Jim?
If we don't get a second on that motion, maybe we could change it to be something about, directing, asking David to work with the planning staff to come back with a draft decision that reflects our conversations. Then we can, then we actually have the vote after that comes back.
All right, so I would ask either David or Kristen, how long do you think it would take to turn this around, and when could we bring this back for a vote?
Mr. Chair, I think that from our perspective, from the planning department, I think a week to 2 weeks would be fine, but I think we may want to check in with our town council to see their availability.
And council approaches.
Yes, a week to 2 weeks is perfectly fine with us, too. A week to 2 weeks is fine with us, too, yes.
Thank you. Okay, well, no one wanted to move to one way or another on this. Lisa, what do we have on our upcoming schedules to take the final vote on this?
Point of order, Mr. Chair, we don't have to have a hearing date for deliberation.
All right, but just for agenda purposes. All right, Jim.
Assuming we're moving in this direction, if this would be okay to time to make a couple of comments?
Sure.
Thanks. Also, I wanted to mention a couple of things to make sure they got into the record. I found the database that we got turned on to by some of the opponents, the EPRI database of incident BESS incidents was really informative. So I want to make sure we have that on record so we can look at it. Plus, it'll be continuing to change as the days go by and the years go by, and as we look at other potential future projects like this. The other thing that was helpful for me was understanding some of the similarities and differences in the Weymouth decision. So if we don't have that on our list of documents, I just want to make sure that was there. So what I took from looking at the incidents and from reading about the latest UL standards is that, as I said at the last meeting, this has been a process. The history of battery electric storage devices has been this race between building a system that people think is good, because no one wants to build a system that's going to have problems, and then it has problems, and then standards get upgraded. In this case, I'm no expert, but I'm really impressed by the latest UL standards and the UL testing. So I went back and looked at the incidents, and I felt confident that the kind of small-scale incidents that could happen from these systems would be able to be handled by our fire department. It's still scary to me. It's still new technology. This game, this race between systems and improvements to the standards is still going on. So I don't know what to do about that. I'm irritated, unhappy with the limits we're looking at in terms of, site plan special permits. I wish we could come up with, conditions that were both valid and were compelling enough to cause the applicant to take some time off. If we wait another year, there's going to be better systems with better standards. I'm not sure we can do that, but I just wanted to share my sense of struggle with this particular application. Thanks.
Thank you. All right. So we will hold this over, and I will put it on the agenda for April 3rd to review the revised draft decision that David and the planning staff and appropriate town staff participate in with council review. Thank you. All right, let's move on. Dog parks. Let's talk about dog parks.
Good evening. My name is Tom Gillespie. I'm the current chair of the Acton Dog Park Committee, and I'm here to bring you a very brief update on the Acton Community Dog Park design. And the intention is for you all to look at that design that is sufficiently completed at this point where we feel we can go ahead and apply for a Stanton construction grant, which you may recall is the next step in this process. But we did not want to apply for that grant without your set of comments and review on the current design. There it is. All right, so we go from batteries to doggies. Next slide, thank you. Real briefly, since we last met and presented to the board, we have gotten the design grant, and we've hired Dennis Dale, Architects, Landscape Architects, and Dennis is here in order to answer any questions that I'm not competent to able to answer. The master plan was funded via the ARPA funds, which you recall, you saw that presentation previously. We have had a public forum on a preliminary design, got a whole bunch of input. We also did a design survey in December, got a whole bunch of input. All of those have been incorporated into the design that was in the packet and that we'll see here tonight. The sewer extension grant was a huge benefit because it eliminated questions about how high would things need to be, et cetera. And so we're now pressing ahead with a design that assumes a sewer extension and the topographical arrangements associated with that. And then most recently, we continue to revisit some of the local dog parks that we have in order to make our latest and hopefully final set of design decisions before we get the whole packet together and send that to Stanton for the construction grant. Next slide. Please interrupt me with questions at any point along the way. We've been working with all the different committees and town staff. Really appreciate all the help and support that we've been getting. I won't read through the list, but last bullet, many thanks to Dean, who's our liaison, and Mr. Town Manager for the support in all of these things. And we did visit the Green Advisory Board and the Design Review Board. Again, got some feedback from them, which is very helpful and again has been incorporated into the design that you will see tonight and that we're seeking your approval on in order to go forward with a Stanton construction grant application. So this is, in fact, a very similar design to what you saw a few weeks ago with the master plan, showing you both the senior park on the right-hand side and the dog park on the left-hand side. We won't go to the next slide just yet, but when we do, it will have a closer up detail of the sort of interesting part of the dog park. You'll notice the shape associated with two different dog park areas, what we call the all-dog area, which is the more triangular piece, almost looks a little bit like a bottle. And then a smaller dog area, which is off to the left-hand side next to it. You'll see the parking lot. We'll have some more details associated with that. Other things that might be interesting to highlight here are, first of all, a retention pond associated with the parking lot that's off to the left and down towards Route 27. Location for the sewer extension pump station is in that orange square, sort of again on the far left-hand side. We're hoping very attractive, essentially walk around the dog park, that sort of light brown area, which would be a walking path around the entire dog park outside of the fenced-in area and connecting up with the senior park that I think Steve had mentioned when he presented several weeks ago. So let's go on to the next slide that sort of zooms in on that bottom portion. No, sorry. Okay, sorry for the distortion here. I had a better picture, but somehow didn't get in here. Couple things to highlight real quickly about the parking area: 16 spaces. There's one handicapped area, and the entrance to that parking lot is off of Route 27 using the existing curb cut that was part of the residence that was there many years ago. There's a shade structure, that purple sort of square, sort of front and center, and attractive, view into the entrance of the dog park. The small dog park, again, is off to the left. The all-dog park is up to the top and in the center. Plantings, some stone walls, some fences, etc. So I'll pause here, see if anybody has any questions about this, anything that we potentially missed before proceeding ahead to get a construction grant for this.
I guess one of the points that has been debated back and forth on your committee, and might be of interest to my colleagues, is have you made a final determination as to what the surfacing material will be within the dog park area?
Yes. And Dennis, I may need your help on this, but it is basically an engineered wood fiber product. So it's not mulch. It's not untreated wood chips. This is specially engineered primarily for use in playgrounds, but when compacted properly is actually ADA accessible and compatible, which actually helped us eliminate some of the walkways that we had originally planned to construct for accessibility purposes. If this wood chip, engineered wood chip surfacing material is, again, properly deployed, you can roll wheelchairs over it, etc., and other people. It's meant for that purpose, and it actually conforms to a standard that I don't quite remember, but connected up. So. Yeah. Sorry.
Hi, I'm Dennis Dale, principal at Dale Design Landscape Architecture. The surface material is a big issue in dog parks. Some people have dogs, they get the little stones between their feet. They don't like it. Some of the dog parks that we've seen, which like in Billerica, they use like a pea gravel. They seem to be fine with it. But in Burlington, they have a combination of stone dust, pea gravel, and then they have a synthetic turf. And you can see where the dogs are running. They love it, on the synthetic turf, and suddenly they'll stop because they don't want to go on the rice pea gravel. So we've been looking at what are the other options out there, and Maynard has a similar dog park. They have a bark mulch system, and we've talked with them, and they do need to be replenished, kind of annually, or at least raked up a bit. Then we also looked at the dog park down in Natick called Fido Park or Eddie's Park. And that one, we spent a good hour there interviewing all the dogs, interviewing all their owners about how they liked that particular, the wood chip system. And I actually have talked with the firm that's constructed that particular dog park, and they said that it worked out great. It was an area where, not unlike this, where they were working in a fairly tight spot. They were taking out some trees, and they said it's worked out great. In the small dog area, the only complaint was that the dogs who are white roll in the bark mulch and get dirty. And I'm like, okay, that's part of the fun, isn't it? No. In the large dog area, the only issue with it was that periodically they need to rake it. So that is part of what we have here, looking at, there's a wonderful dog park down in Falmouth where they have a lot of support, where they have a little shed, and they had actually almost every one of these, the dog parks seem to have a little shed for a rake and some tools that can be locked up and put away. So there is some maintenance associated with it, but overall it was like less expensive. The dogs like it a whole lot better. And the system that you put underneath that, you put a crushed stone and a drainage system, and the way our site drains towards the wetlands there, there will be no issues in terms of it getting soggy, because that was one of the issues in Burlington. The stone dust that they used got really wet. Same thing in Woburn, they had the same problem. They have a low area, and even though it's just crushed stone, or it's actually rice stone, it kind of gets soggy and wet, and they have a whole path around the inside. The problem with putting the path in, when you put a bituminous path down, like, and you have the rice stone, that the stone rolls up on it over time. So it becomes, even though you think you have an accessible path, first of all, you can't see it. If you're in a wheelchair, you might roll off it and all that. So it seems that looking at that, long story short, yeah, that we kind of, the engineered wood fiber seemed to be the best direction to go. So,
Thank you.
Okay, yeah, just one or two more slides. And we can always come back to this. Go ahead. This is our timeline. We are here to ask for a vote to proceed based upon this design to a construction grant. We are wrapping up the costing estimates and the construction documents that Dennis will be helping prepare, which all are part of the application to Stanton. There is some time sensitivity. The design grant we received approximately a year ago, and they like to have your construction grant sort of within a year time frame. So we're not in jeopardy, but we want to get this going not only for Stanton purposes, but for the town's purposes. We've got some ongoing fundraising. We'll figure out, there probably will be some cost gaps just based upon Dennis's assessment that since we did our original estimate of probable cost, guess what? Everything has gone up. So we're going to have to sort of sharpen our pencil on that. And then we'd like to get out to bid with the construction documents, assuming we get the construction grant. We have to determine that, but wouldn't it be great to have that done by fall and get the bid process and then start some construction after that? That lines up with the sewer extension project, which is starting July-ish of this year and then continuing on through April. So I think there's going to be opportunities to coordinate and join together. And I think that's it. Yes. Questions, feedback?
Thank you. Jim.
Okay, let's talk about animal waste.
About what?
Animal waste. Can you say a little bit about the impact of urine on this, these materials?
Sure.
And and are there going to be? I'm guessing there'll be the expectations that people are cleaning up their own dog's dog poop.
Correct.
But I'm just interested about the impact of urine over the if we're only scraping the stuff up once a
Sure.
year, does that create an issue in these other parks that use the same material?
We've asked the parks that are using this substance or something similar to it, that would be Maynard, and then the fairly new Stanton Park in Natick, that exact question, and they have no concerns about smells. In fact, some of the other ground cover materials that have been used at other dog parks appear to be worse in terms of smell. Some of the parks have sand, which is really not working well from that standpoint. So, yes, we took that under consideration. We continue to assume and validate with other parks that as far as the poop goes, number one question, it's fairly self-policing. There will be bag stations, places to deposit, and in many cases, people who are using the park will clean up, in fact, after others that, just to keep the whole thing clean, et cetera. So we think it will be, it can sort of run like we've talked to other multiple local dog parks successfully.
Great. One more question. So I know it's outside your scope, but just want to make sure we weren't somehow losing the somewhat inadequate sidewalk that's on that side of Main Street.
So as part of the AHA project and all of the efforts going on to that, we won't be losing it. There will be opportunities to connect it up, and we'll be looking for that to happen, et cetera. But no, Dennis's design keeps whatever sidewalk is existing there on that side of 27.
Great.
David?
Thank you for all your guys' hard work on this, and Dale for your, Dennis for your, your design here. I was kind of skeptical you guys could fit in 2 parking lots, but you did that okay. You went along with the senior park. That looks good. The overall design of the park looks really good. I like the walkway around the outside.
Yeah.
I have also one question about this material. As a manufactured wood product, does it contain glues to hold wood together? And if so, what's in the glues?
Yeah, the product is a virgin material. It's a product of the timber industry, and it's not something that's recycled from industry, from building and materials.
But it's not like particle board then?
No.
Which is like engineered wood?
It's actually modest size hardwood chips that they select that particular species when they're receiving it from timber.
So the engineering part of the engineered material is just the shape, really?
It's just the shape. It's just that they wanted to give it something other than, sometimes it's called wood carpet.
Okay, thank you.
Okay, Imogen.
Thank you. So similar to all the other questions, I'm wondering if you can talk about whether you know if there's any PFAS in these materials. I know that PFAS can sometimes be an artificial turf, and so I'm wondering if you know if these materials do contain PFAS, or if that might be an aspect of concern.
That's a great question. We can dig into that.
You're talking about PFAS? You're talking about PFAS?
Exactly.
Yeah, that's not in the wood. I'd be honest, I wouldn't know if it was naturally occurring because of PFAS, but I don't think that actually happens. But the wood fiber is not. Matter of fact, we're trying to be as we presented to the Green Advisory Board, and they gave us some suggestions and some ideas. If we can afford them, like using permeable pavers. And that's about it. I mean, there's not too much to a dog park besides the enclosure and mulch and the engineered wood fiber. So no, there's no PFAS as far as we know. So
thank you.
Sure.
Thank you.
Okay, do we have any questions from the audience?
Alyssa Nichols, School Street. First, thank you. I know it's been a really long road. I'm glad we're here. I have a question about the costs, especially since we're going with this engineered wood fiber. It's safe. That's what they use at the playgrounds at the schools. It's all good. But it does get kicked up and moved around by elementary students, so I'm imagining dogs will do the same, if not worse. I remember that we were going to increase the dog licenses to get about $4,000 annually to pay for trash removal, but now that we're adding in this additional labor, I'm just wondering, what is the plan to provide for that? Thanks.
Great question. When we've talked to the parks that have been using this material or a similar material, they report that the costs to refresh them are doable, are manageable within their budgets. We've looked at some of their ongoing yearly maintenance budgets, et cetera, and we feel that it's within the 4K sort of amount that we have. There's also fundraising. There's a Friends of the Acton Dog Park that will be a source should that be necessary. It may be the sort of thing where every couple of years you have larger expenses that then pull from some fundraising for that, but that the annual or the typical refresh amount is manageable within that 4K allocated monies.
Thank you. Jim?
Is the regular maintenance the sort of thing that can be done by, volunteers, friends? I imagine it's like you take a rake and move things around. That's probably not deeply skilled labor.
Yes.
Great.
All right. Sign up, Jim.
Okay, other questions?
Claire Siska, 14 Stowe Street, member of the Dog Park Committee. A couple things on the cost. The engineered wood fiber, as Dennis mentioned, allowed us to not have to put in pervious walkways, so that saved us some money. But also, one of the models that a lot of dog parks use, Maynard uses it, is they have a membership. So you become a member, pay $25 a year, or if you're an organization, maybe you pay $50 a year, and you get some certain privileges. But basically, it's a group that those little membership amounts can help us maintain the park. There's an interesting thing now. I know Provincetown is more of a destination than Acton is, but in Provincetown they have little envelopes at the park, with a little sign that says, if you enjoyed our park, send us, a contribution, $5 or whatever. And we can even save money on the envelopes by just putting up what do you call that little thing that everybody scans, the QR code. We could put it up a sign and say, if you liked our park. And I think particularly when the park first opens and you have more people coming from other towns, that we could probably generate some revenue that way. So we're going to look at a lot of creative ways to keep that money flowing in. Thank you. Thank you.
Fran?
Dog birthday parties, Claire. Who is going to take away the poop? Because I know that a lot of places I take my dogs, they provide bags, but you got to take your own poop.
Yep.
So that could be an
The dog park is is under the auspices of the Recreation Department. We've already had discussions about Recreation Department's already picking up trash at various recreation facilities, and we could slide in the bins and the appropriate access, et cetera, that the Recreation Department would pick that up. There may be, a little bit of money associated with that, but the Rec Department's comfortable providing that.
Thank you. All right. So I think you need a vote. So I will move, since my dog won't let me come back to the house unless I do this. Dash will be very upset. I will move that the Select Board approves the plan and authorizes the Acton Dog Park Committee to proceed with the foundation, the Stanton Foundation grant application.
Second?
Okay, I got a motion and a second, and I did neglect to look for our online folks that want to make some comments. I think we've got one, so I'll hold off on the vote. Matt, can you let, I think it's James Fuscioni in?
It is. He should be able to speak now.
Great, thanks very much. I just wanted to say that given that this is also a senior park as well as a dog park, that it'd be great to have, I don't know if I'm assuming I'm too late for this, but to have benches periodically around the walking path with backs and arms so folks could get up and sit down in a comfortable way. And also if there's room for a transportation van like Crosstown Connect or the Council on Aging van to have space to drop folks off. That way if you can't get a ride, you don't have a car to get there, or you can't walk there, to be able to have access to the park would be great as well. So just wanted to see if that was too late or not to submit that comment, but wanted to say it anyway. So thanks for the opportunity.
Never too late. Tom?
Yeah, thank you, James. Indeed, it was a little bit hard to see in the design projected in the slides, but there are benches throughout, and both in the dog park, inside the fenced area, outside the fenced area, and then prominently in the senior park as well. So one of the nice things about Acton pulling together a master plan for both the dog park and the senior park and the housing authority is that these things have come to light and people have had similar good ideas, and we are working to make sure that that all comes together. In terms of transportation, the Acton Housing Authority will have turnaround sort of van accessible areas that's a little bit far from the dog park, but not that far from the senior park. And so it is a discussion point that all three groups have had in terms of, yes, how can we make access to all those facilities easiest for people.
Thank you.
That's great. Thanks so much. Just want to make sure that if you have a senior park, that seniors can get to it. So I appreciate it. Thank you.
Okay, let's proceed with the vote. Motion and a second. All in favor of the motion, please say aye.
Aye.
Opposed? Abstentions? All right. Thank you very much. Okay, item 6, discuss Acton Power Choice contract renewal.
Mr. Chair, for this matter, I'd like to introduce our defer to our sustainability director. You already know her, Andrea Becerra, and also Paul Gromer from Peregrine Energy. Andrea? Or Paul?
Thank you very much. So I'm here to speak about the time for a new supply contract for the Acton Power Choice program, but I see that Andrea is here, so I'll defer to her. Andrea, if you wanted to kick us off, or let me know if you'd like me to just keep going.
Hi, Paul. No, I'm here more for moral support. I think you should take it from here.
Very good. Thank you, Andrea. So I do have a brief presentation which I can walk us through very quickly if it's possible to put that up on the screen.
So as a panelist, you should be able to share your screen, Paul.
Terrific. So thanks very much. I thought, I'm happy to do it.
And while you're doing that, I can do a little preamble or whatever. So, see, he's quick. We're talking about what's next for our Power Choice program.
That's correct. Exactly right. So we are coming up to the end of the supply contract for the Power Choice program. Acton Power Choice is a community electricity program. Acton is one of about 150 communities in Massachusetts with a program like this. Your current contract expires at the end of December. And to continue the program, you need to enter into a new contract. What I would do today is just give one slide to provide some context and then raise 3 issues that the board might want to consider. The first is when to go out to bid for a new contract. The second is for how long to lock in the prices. And then the third would be whether to change the amount of renewable energy provided by the program. To quickly give you some context, this slide shows the price history of the program. You see the program price in blue and the Eversource basic service price in red. What we can see if we look at the left 3/4 of the slide, that over the most of the years of the program, the town's program price has been very stable. The Eversource price in red there goes up and down changes every 6 months, and on average, the town price has been lower, providing both price stability and savings for the residents. Starting this past winter, January of last year, electricity prices skyrocketed due to the war in Ukraine. You can see the Eversource price went up, the basic service price went up right away. You can see that in red. The town had a long-term contract, so you were able to, the program protected residents against those increases for the first 9 months or so. Then that contract came to an end and you needed to enter into a new contract at what were then market prices. And you can see the Eversource basic service price continued to increase from there. So the issues before us, before you now, the first is when to go out to bid, now or later. You don't have to do this until October, but there are many reasons to consider that it might be advantageous to do it now. The main reason is that prices have come down quite a bit since their peak during their peak last year, and it seems looking at them today, there's more room for them to go back up than there is to continue to come down. Prices could continue to come down, but there's not so much room for that. And we can illustrate that point by looking at this next slide, which shows wholesale electricity prices over time. The different colors show delivery in different years, but we don't need to focus on that so much. Look instead that we see prices were very stable for about 6 years. Towards the end of 2021, they started to come up as we came out of COVID. But then in 2022, with the war in Ukraine, they skyrocketed. But they've come down a good bit since then, and now are nearly where they were right before the war. And looking at this, many folks conclude that, prices could maybe drift down a tiny bit more, but unfortunate events in Ukraine could send them skyrocketing back up. So this could well be a good time to lock in. So that's the first question, whether to do this now or later. The second question is for how long a contract to enter, how long to lock in the prices. Most communities would look at consider 2 years or 3 years. 2 years is a little bit safer. Prices are still volatile now. It's hard to know what's going to happen in that third year. So that would be an advantage of 2 years. The advantage of 3 years is that the prices are a little bit lower if you want to go for 3 years and you do have that longer term price stability. We can illustrate this decision too by looking at that same wholesale price graph again. The town has made very good decisions on contract term in the past. So you entered into a 3-year contract in just before 2020, and so locked in 3 years of prices when prices were low and stable. And that's what helped the town to protect residents from the early price increases due to the war. So we entered into a 3-year contract at a good time. And then last year, when prices were so high and so volatile, the town entered into a shorter contract, just over 1 year, thinking that there might be room for prices to come down. And that too turned out to be a very good decision because prices have dropped a lot. And if you enter into a new contract now, it'll be at a much lower price than the residents are paying today. So this illustrates the, different times, different lengths of contracts are preferable. And it seems that now you might want to consider 2 years, you might want to consider 3 years, but that's the issue before you. And then just to quickly raise the third question, it's whether to change the amount of renewable energy provided by the program. In the past, with each new contract, the town has increased the amount of renewable energy. So that's been your practice. However, you might want to think that, you just increased it quite substantially a year ago, so that wasn't so long ago. And Acton is already very near the top of the state for the amount of renewable energy. And we can illustrate that with this graph, which just shows for all the communities that are providing extra renewable energy through their programs, you can see that Acton in red is already the third highest in the state at 40% and much higher than pretty much almost any other community in the state, including other sustainability leaders like Lexington, for example, which also has a wonderful program, but not as much renewable energy as Acton does. And so the specific task you might want to consider tonight is to authorize the town manager to sign a new electricity supply contract and then give whatever guidance seemed appropriate on the three issues that we discussed and any others that were important to the board. So that's my quick overview of the issues, and I'd be happy to answer any questions if there are any.
Okay, thank you. Questions, Mr. Groner, from the board? Jim.
Hi, Paul. Thanks again for a great, clear presentation. I'm wondering if, rather than giving you specific guidance on the 2-year or 3-year contract, if it would be useful for you guys to have, the slack to take a look at the bids and decide. As I recall, you typically get bid information and, decide within that day. It's a very rapid turnaround process, and we could see how volatile those prices were. So that was, I guess, my query to you is whether it would be useful to have, rather than specific guidance for us on the length of the contract, just go ahead and, do the deal that makes sense to you.
Yes, so I do think that would be wise to give the town manager the discretion to make the decision about the term on the bid day. It may seem, looking at it today, that one or the other would be preferable, but as you say, we'll get bids for different terms, and it's not impossible that one would really stand out because it was a particularly attractive price for that term, and it would be ideal if the town manager could make a decision based on the prices that he sees.
Okay. Other questions from the board? David?
Yeah, I think that the term is important, but actually I think giving the town manager discretion to sign the contract, when to sign the contract is kind of the most important thing. It seemed from Paul's graphs that it was kind of the end of the summer might be a good time, but whatever makes sense. I think, again, the town manager could also have discretion on the term, but I'm thinking longer is better, because if we're able to hit the low point this year, then I think that, over the long term, prices are not going to go down much, right? If we hit a high point, they're going to go down, but if we hit a low point, they're not going to go down very much. And I think residents appreciate the price stability over a long period of time. And also, I think we should increase the renewable by a little bit, by 5 or 10% for EPC standard, something like that.
Okay. Other comments? Imogen?
Yes, I think that it's fine if it's up to the town manager's discretion, and I think that to David's point, and to reiterate that, I do think that we are seeing a downward trend, and I agree that, we are hitting that plateau that we've seen in previous years, that it's not going to go much further than that. And so I think that locking in a longer contract might be better. So my inclination would be towards the 3 years. But yeah, in terms of increasing renewable, that would be, I think I would be in favor of that. If I remember last year, I think we were also given information on what that would mean financially, how that would increase someone's bills. And so maybe some more info on that might be good, but yeah, would be supportive of increasing renewable.
Well, I'm certainly in favor of giving the town manager his opportunity to, go out to bid when he thinks most appropriate and sign when it's appropriate. I too would favor a longer-term contract, but it all depends on what the bid results are. But I'd look favorably on a 3-year contract. Going out to bid sometime during the summer or whenever you advise. I'm frankly not in favor of increasing the amount of renewable in this contract. If people really want to go all in with renewable, they certainly have the option of doing that. I'm just not in favor of dragging everybody into it and assigning that cost to every member of the community. So I think we're already appears to be the third highest in the entire system as far as our amount of renewable. And there is the option to go 100% if people want it. I think that we should probably leave that amount of renewable right where it is right now, which I think is about 40%. Jim.
Just to ask the question explicitly, which I think was being asked, is what are renewable prices looking like these days? I gather they're not quite as volatile as the wholesale prices, but I'd be curious to understand what additional renewable amounts are going to mean.
Yeah, so forgive me for not having those numbers just in front of me, but I can pull them up quickly in a moment. I think you are correct that the renewable prices have not been nearly as volatile as the wholesale electricity prices. So those are very close to where they were when you last entered the contract. So if you were to increase, say, 5%, that would be on the order, I think, of about $1 a month for a typical resident.
Okay, thank you. See if we have any comments from the public.
Thank you so much, Chair again. Can you remind me whether or not when we buy all solar, whether it's actually solar? I know you can't track, the P's around in all the ions and electrons, but how do we know that it is actually solar? I get this question all the time and I always forget the answer.
I think Jim has the answer.
It's actually typically wind rather than solar. Because of the way that solar gets an extra price bump to it. So typically when we're buying RECs, we're buying from a couple of large wind projects.
Okay, so our money effectively buys electricity from those projects and gets into the mix somehow.
Yes.
And the 40% is for the folks that haven't chosen 100% and haven't opted out.
Correct.
So,
we sometimes call it opt-down. I mean, so you can opt down,
okay.
Or you could actually entirely opt out.
Coal. Opt coal, right?
Yeah.
So given what he just said, I think he said 5% would be $1 more per year. And it's only a month, sorry. And it would be only one phone call to get the price to the opt-down. I hope that you go as high as you feel comfortable with, 50, 60, 100, 80%, whatever it is, because you can always opt down. Thank you so much.
Thank you. I believe we've got one caller online. Matt?
Deborah Symes. Deborah, you should be able to speak.
Thank you. You can hear me?
We can.
Okay, great. Thank you. Deborah Symes, Concord Road. Couple of things. One is I just want to remind everybody that in the last contract, which was a 15-month one that ends at the end of December 23, that what we contracted for in the standard option was an extra 40% of discretionary Class 1 REC renewable. We have to remember the 40% layers on top of RPS, the Renewable Portfolio Standard, which is what the state requires of all providers, all electricity providers. So in 23, that RPS is 22%. So we're actually getting 62 in 23. It'll go up to 24 in 24. So we'll get, 24% plus whatever our additional is. So the increments are rising a bit in any case. Starting in 25, they start to go up by 3% per year. So there is some kind of increase hardwired into the way the RPS works. all of that said, you know, I think it's a great idea to give the town manager the flexibility, and I'm sure Andrea will weigh in with him, and, you know, around term versus content versus price, or not versus, but in, you know, in addition to considering price. The other thing I just want to remind people of is that, and Paul can correct me if I'm wrong, but I think I'm not, that there is a way to step the renewables through the course of the contract. So if we did go to a 3-year, it might be possible, I don't know again what the pricing might look like, but it might be possible to, you know, have in the first year just our existing 40%, in the second year bump it up to 45%, in the third year bump it up to 50, you know, that sort of thing. So Paul can tell me if I'm wrong, but all other things being equal, I would be inclined to, you know, if we were going to go just for a fixed amount of renewable in our standard option, I'd be more inclined to go to a slightly shorter contract if we're not going to step it, you know, and bump it up another 10% next time around. That's it. Thank you.
Thank you. Jim.
So in thinking about where we should set this percentage of renewables for the next contract period, I have a couple thoughts. One is, well, to reiterate what Deborah said about the RPS going up to 22 and then 24, and then if we had a 3-year contract, we'd see it up at 27%. So we're going to see a nice increase in renewable energy in our supply anyway. The other thing is, to me, you know, Acton's one town out of 350 or 150 of the towns that have programs like this. So for me, what's important is that we at least maintain our leadership position up there in those, you know, top 3 or so, because that helps pull other towns. I mean, I remember when we looked at this chart before we were up there, we looked at you know, we looked at Lowell and we said, hey, we can do as good as Lowell, can't we? You know, we can do as good as those other towns, and it helped pull us up. And I think now we have a role to play in helping other towns pull up if we stay up there in those top 3. So I don't see a big need for going up or not at this point in time. I know we had really, at least to me, moving and eloquent speakers about making 100% the default. I think that's going to be a big decision if it comes. So I think of that as, you know, something we look at after this next contract. I think of the short contract that we're just in the middle of and the next contract as like sort of combined to be one contract period. So since they'll add up to about 3 years or 4 years. And then we can take the time to consider where prices are at. Are we ready to, you know, to take a big leap forward? So I don't feel a big need to increase it for now, but depending on, you know, where the board's at, we haven't heard from everybody yet, but I'm okay with either it staying the same or going up some.
Thank you. Fran.
I was curious, could I ask Paul? Sure. Paul, could you answer Deborah Syme's question of a contract being stepped? Yeah, please.
Absolutely. So yes, it is possible to do that. So you could change the amount, have them, as Deborah suggested, you could have the amount of renewable energy be X in the first year, X plus 5 in the second year, X plus 10 in the third year if you wanted. Typically, the way towns do that is they, in effect, charge the average price for the 3 years, all 3 years, so that the price doesn't change every year. You just build that step up into the price from the get-go, from the first year.
Thank you. David.
So again, I think the residents appreciate price stability. You know, but I think it's, you know, our choosing carbon-free power is the single biggest thing we can do. You know, of just about anything we can do to fight climate change is certainly the easiest step to take. I would like to see us make an incremental improvement, like I said, of 5 or 10% this time. If, you know, one of the things Deborah suggested was doing 10% next time. I'd rather do 5% this time, 5% next time myself. I think we need to continue our upward trend, but it's a very small difference. and along with the base point steps that'll take us up at a little bit of rate. So I would propose we do 5%, and again, in terms of price stability, aim towards the longer end of the spectrum, and let give the town manager the discretion to do something different if that makes sense, and then letting the town manager choose the time this year that seems the most advantageous to us. Jim.
I had a question for Paul. So there is this, both the risk and the opportunity that as the price goes up, more people will opt down, which would then, undo the carbon impact, since they'd be going back to the renewable portfolio standard of 20, 22, 24, 27%. So I'm wondering, Paul, how many users have opted down, and out of how many users?
Yes, so that's a good question. And we do have some recent experience with that when the town, when you entered your most recent contract, which did, because prices had gone up so much, was a big price increase. And the town notified all the residents of how the price was changing and what their options were. So in that case, what we had, the biggest impact was about 5% of the customers in the program opted down. So they went from the standard program to the basic option. We had 1% of customers leave the program, but they were actually counterbalanced by 1% of the customers who opted up to the 100% green, and 94% of the participants made no change at all. They stayed where they were.
Thanks.
Thank you. I think it's because the way this happens so seamlessly, I think a lot of people just don't want to mess with it. And so I think, considering that, I think it's incumbent on us to be cautious about how we spend folks' money. Yeah, they've got the ability to do this, but how many people actually will, and are we actually dragging people into higher costs than is necessary? That said, I would be willing to put together a motion that we move to authorize the town manager to go out for a 2 to 3 year contract with the emphasis towards a longer contract, and increase the renewable by 5%, and that the decision as to timing of the contract, I will leave up to the town manager's discretion.
Second.
Okay, moved and seconded. David?
Just understanding that and I think there is a comment, I don't think we need to change the motion, that the increase in renewable by 5% is in the standard plan.
Yes. All right, got a motion and a second. All in favor, please say aye.
Aye.
Opposed? Abstentions? Thank you. Thank you, Paul. Appreciate you coming in.
Thank you very much.
Okay. Next, discuss and vote on warrant articles. John.
Well, I would actually defer to Mark on this. Made some updates to the warrant, and you can give us an update on where we are as of today and what work is left to do. And if the board so chooses, it could discuss some of the articles and decide to make recommendations.
Thank you. So the large spreadsheet with the colored cells indicates mostly articles that are still waiting for some information or for your recommendation. We did combine the 2 groundwater protection district articles. There was one related to Acton, one related to Maynard. They're now in the same article. And we were also advised by the AB schools that Article 8 will no longer be necessary. So we'll be taking that off the list after this meeting. We don't have the CPC votes yet, so that article is still outstanding. There are a few others listed here that are either placeholders or just need more fleshing out, so to speak. But otherwise, the financial articles are in good place. The capital, the operating budget, and the school assessment articles are in good shape too.
Okay, thank you. Yeah, I would like to move ahead with the financial articles. See, the budget transfer. Is that going to be something that's required? Do we recommend it, or how do we proceed on that one?
That remains a placeholder, and I would just suggest no action.
Yeah, you could just list that as deferred. So if something does come up in between the posting of the warrant and town meeting, you could make your recommendation at the meeting.
Thank you. Okay, town operating budget. We've heard the presentations. This has been available for people to ask questions, and I haven't heard a lot of discussion. I will entertain a motion to recommend the town operating budget.
So moved.
Second?
Moved and seconded to recommend the town operating budget. Discussion? All in favor of recommending the town operating budget as presented, please say aye.
Aye.
Aye. Opposed? Abstentions? Thank you. Okay, town capital, public works, public safety, and public celebrations. Article 5.
Question?
Jim?
As written, does it reflect our latest discussion about public celebrations?
John?
Yes, the direction from the board that I received was to work diligently on a future celebration that includes fireworks, and this article would be funding for that future celebration.
Perfect, thanks. I'm happy to move that we recommend the first of the town capital items, the public works, public safety, and public celebrations, number 5.
Okay, could I get a second?
Second.
Okay, moved and seconded. Further discussion? Call for vote. All in favor of recommending Article 5 as written, please say aye.
Aye.
Aye. Opposed? Abstentions? Okay. Article 6, Town Capital Infrastructure. This requires a 2/3 vote. 2 items, DPW facility improvements and construction of a tight tank at Station 3. Any discussion? All right. I will move that we recommend Article 6 as written.
So moved.
Okay, moved and seconded. Discussion. Jim?
This seems the appropriate moment to channel Charlie Cadillac and say we spend the least amount of time on the most expensive items.
Well, let's see how long it takes us to work on the school budget recommendation. Okay. All in favor, say aye.
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 Opposed? Abstentions? Okay, that's recommended. Article 7, Acton Boxborough Regional School District Assessment. David, you're the liaison to them.
So this has been a tough budget year for the school district. Overall, they're to meet the required budget numbers, they had to cut 13.4 FTEs. Unlike last year they also made personnel cuts, but last year was, I think, all, if not mostly all, non-certified staff, so non-teachers. This year was, I believe, all teachers. So their goal was to keep their budget increase under 3%. They did that. Their budget increase is 2.77%. The increase in the assessment to Acton is 2.84%. I can give you the numbers, the total budget. Maybe I can just give you round numbers. I know they say this ends at town meetings, but I'm just going to give you, the total budget is almost $106 million. The total assessments to both towns together is almost $86 million. And Acton's assessment is almost $72 million. So, and again, that's up 2.84% from last year. Happy to answer any questions.
Jim?
How do they end up in that all-day kindergarten discussion?
They originally had a plan to go year by year to lessen the tuition. And then last year they had wanted to do it faster and kind of take one jump in the end. They ended up, the going faster in the end didn't work, and they've reverted to their original plan of taking a step and reducing the tuition for all-day K. So almost all the kindergartners take that tuition. There is financial aid available for low-income folks, but there are very few. I think there's one section of half-day K.
Okay. I will say David and I have been involved in the ALG process, and it went pretty smoothly from my point of view. And they did come in kind of with the guidelines that we started out. So I always like to see bills come in lower, but I'm thinking, I think it seems like a reasonable budget. If $100 million plus can ever be considered reasonable.
Can I just say, they've had a number of challenges as well, right? They've introduced a program to help address some of the mental health situation introduced by the pandemic or exacerbated by the pandemic. So they have this new program, which is well regarded. We'll see how it ends up working. Things like that take money. They also have a lot of multilingual students or English language learners. That number has gone up, and so they have to hire. Sorry, I keep hitting this. They have to hire a little bit in that area for English language teachers, and that that hurts their they had to make up for that elsewhere. So, Mr. Chair, can I make a motion? I move to recommend the Acton Boxborough Regional School Assessment.
Any second?
Sorry, second.
Okay. Moved and seconded. Further discussion? Okay. All in favor of recommending the Acton Boxborough Regional School District Assessment, please say aye.
Aye.
Aye. Opposed? Abstentions? Okay. Item 8 is going to be removed. Minuteman Regional School District Assessment. Jim?
I'm happy to vote on this, but if there's any questions, then we should probably put it off to a future meeting, because I haven't studied the budget as carefully as I'd like.
Okay. What's the will of the board? Do you want to vote on it, or would you like to have Jim come back?
I'm happy either way. I've seen the presentation from Dr. Dawson, and so I'm happy to do it either way.
I'd lean towards coming back just because this would be my chance to practice.
Okay.
Making sure it's all in my head and saying it out loud.
Let's skip this one and we'll move along. We'll bring it back. CPC, we'll have a report from them shortly. Placeholder for the library.
Yes, so the update on this is that the town manager and I are working to present the draft of the warrant article to the Citizens Library trustees at their next meeting on the 23rd, hopefully giving them enough time to review. And then we're planning on bringing this to the select board on April 2nd. And correct me if I'm wrong, but I think that's the plan as of now.
I think that is the plan that I look forward to working with you on, except that April 2nd may be early. I think we were looking at the second April meeting, not the meeting on April 2nd, but the second April meeting.
Oh, okay, that works as well. And that actually would be preferable. I think that our trustees would like some time to review that, so that actually would work, yeah.
Okay, we'll defer on that. Placeholder on the conservation restriction. We've seen the latest CR, but I believe that that's being reviewed by council at this point. So I would roll that one over a bit. Men general bylaws. Jim, these are kind of yours. You ready to go, or?
If I could have your indulgence, I'd practice my 4-minute talk about these things. Okay. So I'm going to talk about both Articles 13 and 14. 13 is the one about the specialized stretch energy code, and 14 is the one about joining the fossil fuel-free demonstration program, which we would do by amending the bylaw that we passed 2 years ago. So 2 years ago, we passed overwhelmingly this building with clean energy bylaw, that chapter AC of our bylaws that basically said if you want to use fossil fuels in your new building or your major rehabilitation, you would have to get a waiver from the building commissioner, which would be applied for rare purposes where the use couldn't be accomplished with electricity. And in thinking about that, that's typically going to apply for commercial cases. We understand residential housing prices costs a lot more clearly because there's houses. We know what houses are like, but the variety of commercial uses is obviously a lot wider. So there are things like, if you want a restaurant that was primarily walk-based, those can be done with electric walks, but it's really expensive. So it'd be the sort of thing that we would expect a waiver to apply for. So when we did pass that in 2021, we also passed a home rule petition that said to the legislature, hey, please let us do this thing, even though normally the state has control over building codes and the regulation of fossil fuels. The legislature considered that because they had 7 towns asking them for this very similar things. But instead of actually approving our petitions, they approved in the 2022 climate legislation a process for towns to participate in a demonstration program, a fossil fuel-free demonstration program. This is done in 2 stages. First, towns that are green communities would opt up to what's called the stretch energy code. But before I say anything about that, I should say a tiny little bit about energy codes, because I found this very confusing and there's a lot of jargon. So the first piece of jargon is this home energy rating system, or HERS. And that's a number that's used a lot in all the different layers of the energy code now, where 100 is about homes that were built to code in 2016 on the average. We're now looking at homes that are, much better than that. And 0 would be, it uses no energy at all. So it's like, it's a shed, that has no energy use at all. The numbers are coming down though, and the codes are getting tighter and tighter. The other thing to talk about is just the layers of the code. So we've got, there's a whole different document I have. Sorry, I don't have this integrated. Open link. Okay. We've got the International Energy Code, which is sort of like the World Series. It's not really applies internationally, but it applies to the U.S. and Canada anyway. And that's the basis of all the Massachusetts energy codes and most state codes. There was a change from International Energy Code 2018 to 2021 that became effective on January 1st, 2023. Many small but positive changes, like little things like if you have an outlet on an outdoor wall, it has to be air sealed. Then there's Massachusetts makes amendments to that International Energy Code. I'm happy to send this whole thing to you, Imogen, if you don't want to have to take all the notes. Because I'm just reading right from this and summarizing it. So the Massachusetts adds things to the International Energy Code that apply to every town in Massachusetts. So there was a slight decrease in the improvement in the HERS requirements. And it has things like commercial, on the commercial side, there's new electric car charging requirements for parking areas. Then there's the stretch code, which applies to all of our green communities, including Acton. That's now an increasing number of towns in Massachusetts. I think we're way more than half now, but I don't have the exact number in front of me. The new stretch code has higher residential HERS requirements that start on January 1st, 2024. Acton is at that level right now if we do nothing. But there is this specialized opt-in stretch code that basically on the residential side allows 3 different pathways for new houses. Basically a zero energy pathway where you build like to passive house standards and you put enough solar on the roof to provide all the needed energy. An all-electric pathway and a mixed fuel pathway where you could have a mix of electric and natural gas or other fuels, but it has to have a tighter HERS rating than the all-electric pathway, and it has some additional wiring requirements. You basically have to be ready to go all-electric over the next couple of decades. You have to add enough wiring so that you could have heat pumps and you could charge an electric car. The start times for that is up to municipalities, but the way our language is written is that it would start on January 1st, 2024. Then there's the 10 community demonstration. That's Article 14. And the DOER has drafted regulations for this. They don't have their final regulations until March 31st, so warning, we may need, the motion on the town floor may need to make some little adjustments depending on what that final language looks like, but we've got a pretty good view of what it looks like. Basically, it would allow only the all-electric pathway from the specialized stretch code in new construction. In major renovations, which is more than 50% change in the, so the work area is more than 50% of the construction for commercial, and is more than 75% of the current area of the house for residential. In those cases, you can't add fossil fuel combustion equipment to that new area, the area that you're working on. But you can repair stuff if it's already there. As we said, we already have a bylaw that allows a waiver and appeal process. We would just keep that same waiver and appeal process. It doesn't, the legislature said you can't apply this to certain health facilities or biolabs. So we can't have this total all-electric requirement for those kinds of facilities. If we pass such a bylaw, which is currently written as an amendment to our existing Chapter AC, DOER still needs to review and approve it. They've said they'll do that by the end of November, in addition to the usual Attorney General review and approval. And then we don't know when it would start. I had initially hoped to start it for January 1st, 2024, so it would come in at the same time as the specialized stretch code. The draft from Town Council suggests that we should wait 6 months after the DOER approval, which would take us out to May or so. but that's an open discussion to have with the town council. And I guess the only other thing I'd say is just sort of remind us that when we were looking at the bylaw in 2021, it got the approval, the recommendation of the select board and the finance committee, and passed overwhelmingly at town meeting, mostly because we were going to be able to make big advances on our carbon emissions for basically stop things from getting worse anyway, that new houses would come in and new buildings would come in and they would be, all electric. It was like a good start. The retrofitting our existing houses, which is not part of this program at all, but taking our existing houses and, changing them over all electric systems is a tricky question that has to go house by house. Each house is different. We have a coaching program and we work with a bow to help people through that. But we're certainly not at the point of trying to mandate that. That's not what this is about. Other frequently asked questions. Isn't it bad to make people depend on electricity because electricity is like only one thing? No, it's okay, because in fact, all 99% of our heating systems already rely on electricity. If there's a power outage, your house is going to start getting colder. If your house is well insulated, it's going to get colder less quickly. So it's good to have good insulation and air sealing. And finally, if you want to back up, there are fine battery backup systems that people can have if they really don't want to, get slightly colder as the power goes out. But there are no backup natural gas systems. No one's putting in, a natural gas facility in their backyard. So if you want a system with good redundancy, electricity is the way to go. I think that's it. I know I took more than my minutes, but it was fun. It was good practice for me.
Well, I think my inclination would be to maybe hold off on this for a little bit, since we're waiting for the guidance from DOER, which will come in later on in March. But, specifically I think this is going to take, I want to hear input if there's any residents that are concerned about this. My reaction certainly is that I have a propane-fired furnace in my house. It requires electricity in order to work. But once you've got it started, it takes considerably less electricity than if I was just relying on my electric split systems, which I also have in my house. So I think, if there's a total blackout and you don't have a backup generator, why, you're in a lot of trouble. But I'm concerned about, a reliable supply of electricity worldwide. Grid-wise in the system, do we have enough capacity in our electric grid right now? I'm reminded of the failures of the electric grid here back in, September, October, and Eversource had to bring in diesel-powered generators. So I'm concerned about that. Also, as far as redundancy, I think, sure, a lot of people rely on natural gas, but there are other people that have propane, which certainly provides a great deal of redundancy. And you're not relying upon, you're not concerned about the failure of the gas grid because you've got your 500 or 1,000 gallons of propane safely in your yard. So I'm not convinced that going 100% electric and having no possible backup is really that good an idea, and I'd hate to force people into that situation. But I think this is something we can talk about again at a subsequent meeting when we go into this in greater detail. And, we'll see if we get some public input. Speaking of which.
Thank you. Tom Beals, 171 Willow Street. I agree with you, Mr. Chairman. My concern is with the grid, we have seen attacks on substations in various parts of the country. 60 Minutes had a program some time ago on the reliability of the grid and its susceptibility to attack. The comment was made that an attack on 9 substations could take out the electricity supply for a large area for a period of months. The issue of electromagnetic pulse, and this could be from a coronal mass ejection from the sun, as happened in 1865, the Carrington event, something worth looking up if you're not familiar with. There was a congressional committee, I think in 2017, I have the reference, which I can supply if you wish, estimating that per decade, with the combination of a natural electromagnetic pulse, that is a coronal mass ejection, combined with the possibility of terrorist or international actor electromagnetic pulse, the estimate was in the order of 10% per year. And I'm sorry, 10% per decade. And frankly, I know opinions differ on this, but I consider that to be a more likely event than some of the worst case scenarios for global warming or climate change, however you prefer to phrase it. So bottom line, the natural gas system is an independent, the infrastructure is there, is an independent energy supply. And there are advantages to chemical energy as well as there are advantages to electric power as an energy source. So I would like to see people have the option to retain the independent power supply from natural gas. Thank you.
Thank you.
Chair, again, this is only for brand new houses, which we don't need anyway, right? Is that right? Did I get that idea?
And major like gut rehab.
Okay,
yes.
okay. So the people that can afford a huge rehab or a gut rehab that would be subsidized by the town, maybe we could exempt that somehow. But we'll work on that later when we have a land trust, a housing trust, et cetera. I feel like there's more to this because if we want to be good neighbors to the world and we continue to burn coal to heat big houses and allow more building than we actually need, things like what's happening all over the world where people that are less privileged, brown people, our islands are getting sunk. Right now, there's mudslides and tornadoes and crap that's happening because we're all sitting around thinking, man, it's so easy to be just right here and we don't really need to do anything. And oh gosh, we might have a tiny little bit of risk. This is just how I feel. Maybe my numbers are wrong, but I feel like this is now you've got the 278 countries begging us to get our act together and cut this out. And so I'd like to also mention a power grid independence, like what Foxborough has. They buy their own power. They operate their own power company. Just look into that some other day. I have a question for the experts. Can somebody who uses gas do a backup with propane? And if not, there is no backup to the gas pipe. Is that right?
You can change over appliances from natural gas to propane, but it requires a change in burner.
Right. So like if it goes out and it's going to be out for the week, I still don't have any backup if I'm on gas, right?
That's
But again,
correct.
this isn't for me. This is for new houses that we don't need. So I urge you to approve this as soon as possible. And according to the risk assessments I'm looking at, the biggest terrorists are white nationalists. Thank you so much.
Thank you. David.
Yeah, so I think a very important point here, Jim, in your presentation to town meeting is this doesn't affect any existing houses except for gut rehabs or major rehabs. So we're not, these changes don't require, anybody to give up their natural gas or anything. I also think it's important that these two issues get separated. I would present them separately. You do what you want, but I know them very well, and I think they get muddied if they're mixed. And so I would present this stretch code and then accepting the law from the legislature. And, you know, those things that the speaker mentioned about, you know, terrorist attacks or EMP or whatever, nothing, you know, the natural gas is certainly not going to help there or anything else, right? Natural gas is compressed using power from the grid. Propane is compressed using power from a grid. Oil trucks are filled using power from the grid, right? If we have no power, we are in dire straits. And in fact, the whole green movement with distributed power generation from wind and solar makes for a much more reliable grid than what we have today.
Thank you. So, looking at the time, I think we've made some good progress, and we can take this up in more detail at our next meeting. I know there's a couple of issues with the planning board and zoning, and I don't believe they had their final vote anyway. So, take this up at our next meeting. The item 8, the Colonel Francis Falkner Senior Exemplary Volunteer of the Year Award announcements. Has everyone here made their nominations? And is everyone prepared to make their nominations public? All right, well, I'll start. So I have nominated Stephen Trimble, who is the chairman of the Recreation Commission, chairman of the 250 Committee, and is serving as vice chair of the Community Preservation Committee. Made some excellent contributions to the town. Jim.
So I'm nominating somebody who's been on also a lot of different committees over the years, and he was the person who created this Falkner Award in the first place, Peter Barry. So it's fun to be able to make the award go around full circle and nominate him for one of these awards.
Thank you. Imogen.
Thank you. I'm really excited to nominate Madeline Cruz. She currently serves on Housing and Climate Justice for Acton, as many people are aware, and then also the vice chair of the Human Resources Committee. So just really, really excited to nominate her this year. She's rallied and galvanized so many of the people in our town. She's highlighted the needs of renters, and so really grateful to be able to give her this.
Thank you. Fran.
I'm excited to nominate Catherine Yusoff. She is the chair for the Economic Development Committee, and I've just watched the EDC has just transformed with her at the helm. It's become, you know, positive, energetic. There's a vibe that is just coupled with Julie, our economic director, a development director, is just, they both work really well together, and they've done so much for the EDC in the town. So I'm excited to nominate Catherine.
Thank you. David.
Yeah, I'm pleased to put forward Andy McGee as my nominee. Andy's been a chair of the Open Space Committee forever, and before that he was on the Select Board and other things. So
great.
More on Awards Day.
Great.
Which is when? I've already forgotten. The awards day.
So the awards date is, because it was just changed, April 26th? Pardon me?
April 23rd.
April 23rd is a Sunday.
26th? Okay, great.
April 26th. We'll have the award ceremony right here in this room, I believe. Great, thank you. Quickly, town manager update and updates from select board members. John?
Thank you. Just wanted to note the construction that started around the common out here in front of Town Hall. It will be approximately 11 weeks of construction, hopefully sooner, but that's the schedule. And we believe that it will create some delays, but that traffic should be able to get through throughout the duration, and that it's going to look great and be a lot safer for pedestrians and everyone else that's on the road when it's completed.
There will be.
So just to clarify what the construction is, it's going to be roadway improvements to make the shoulders and the sidewalks and the bike lanes and everything else that are there safer, creating the crosswalks better, and it will create a new traffic pattern around Common where to go, you couldn't get to the fire station from in front of the library. You have to go around and take a left to get to the fire station, and then it's one way back this way, back towards the library. So it'll be less moving parts at some of the more dangerous intersections like the one at Newtown and Concord, and I think it'll improve the overall safety, and you'll note that the monument is fenced off with orange fencing. The contractors are supposed to not go in that area because it's a cemetery, and so they shouldn't need to, and that fencing is there just to make sure that they know that.
Okay, thank you. My one announcement is May 1st, which is a Saturday. Pardon me, April 1st, which is a Saturday.
Yeah.
We'll be doing a tour of the Acton Public Works facility. We opened the public. Starts at 10 a.m. Walking around the facility, taking a look at the conditions. There'll be some DPW staff there as well as myself to try to explain things. We do have, on May 1st, we will be discussing the approval of $1,225,000 for the design of a new facility. So this would give the public an opportunity to familiarize themselves with that 50-year-old structure. The entry to it will be from 14 Forest Road. Any other comments from other members? Okay, Jim.
Let's see. A number of groups are sponsoring a talk on March 22nd. That surely is 22nd. Uh-oh. I should have had this practice.
That's Wednesday.
Wednesday, thank you, of course. And one of the groups sponsoring it is Energize Acton, which is a joint project of the town of Acton and the Acton Climate Coalition. This is called Creating Beautiful Sustainable Lawns, a webinar with Chris Osborne, who is a nationally known expert on organic, sustainable lawns. It's a Zoom meeting. You can sign up right at energizeacton.org, which is where you can also find out about all sorts of other environmentally awesome things you can do.
Thank you. All right. If no one else has anything else, I will admit to an oversight on my part. Prior to the meeting getting started, a member still in the audience asked if he'd be able to comment on on one of the citizen petition articles, and I said, sure, don't talk about it during citizen comments because there'll be plenty of time when we're talking about warrant articles, and we never got that far down the list. So, Mr. Beals, if you'd care to make your comments, with my apologies, they're a little out of order, but let's hear what your concerns are.
Thank you. This was in regard to the proposal last meeting for apartment residents to have access to compost facilities. I recall a little bit of biographical note is relevant. I grew up in a town where subsistence farming was still part of the town, and so I grew up with composting and et cetera. I compost now at my house. I have a small chicken yard. We have quite a nice little working ecosystem. So and that combined with an undergraduate degree in microbiology, it may be an odd thing to be fascinated with, but I am fascinated with composting and the process. And as I said, I recall being an apartment dweller and being frustrated at not being able to compost. However, the proposal was, as I understand it, and I welcome clarification, the proposal was to make this program obligatory on landlords. And I thought that was not the best first approach to the problem. And I'd like to see it move forward, but I think I would like to see better definition of the problem, better statement of the problem, and I guess that concludes my thoughts. Thank you.
Can you make a quick comment? Sure. Mr. Beals? Mr. Beals?
Tom?
I just wanted to mention that if you thought you had a better idea, you can offer an amendment at town meeting for what that idea is. It's especially effective if you let the moderator know ahead of time what amendment you'd like to offer, right? So if you have some idea that'll work better than requiring landlords to do, then bring it up at town meeting. I'm just offering that. We can't change the wording. The citizens' petitions, once they're signed by the petitioners, that wording is fixed. We can't change it. But you can offer an amendment on the floor.
Thank you.
It's also helpful to work with the petitioners who will support your amendment, potentially. I understand what he's saying, and I think his idea is about a voluntary pickup and everybody can organize. And I love that because who needs government anyways, you know what I mean? Like we could just not have any government. We could all do volunteer snow plowing. See what I'm saying? So ideally that would be so cool. And I would say, organize it. And then I would pull my petition. It's not even mine, it's Madeline's, but I'll recommend that we pass over it. So thank you very much for your concern. And I look forward to hearing an amendment. Thank you.
Thank you. Okay. Consent agenda. It's getting close to the nightly news, that's for sure. Item 9, accept meeting minutes, February 27th and March 6th, 2023. Item 10, approve a one-day alcoholic beverage license, South Acton Congregational Church, 35 School Street, April 1st, 2023. Item 11, approve a one-day alcoholic beverage license for Carol Barron at Narrow Park Pavilion on July 16th, 2023. Item 12, approve a one-day alcoholic beverage license for Julie Verzdusko at Narrow Park on May 7th, 2023. 13, accept a donation from 421 Gas, Inc. for $1,500 to support the 2023 Summer Concert Series and special events. Item 14, accept a donation from St. Matthew's United Methodist Church for $300 to support the Acton Pride Festival. Item 15, accept a donation from Insulet Corporation for $2,000 to support the 2023 Summer Concert Series and special events. Item 16, accept a donation from Protect Towing and Recovery Incorporated for $1,500 to support the 2023 Summer Concert Series and special events. Item 17, approve Arbor Day Proclamation for April 28th, 2023. 18, appoint Michael Carpenter and Patricia Sutherland as full members of the Economic Development Committee, the term to end on June 30th, 2026. Item 19, appoint Paulina Nibby as a full member of the Open Space Committee with a term to end on June 30th, 2026. Number 20, appoint Stephen Trimble as an associate member of the Land Stewardship Committee with a term to end June 30th, 2024. 21, appointed Adam Nolde as an associate member of the Land Stewardship Committee with a term to end on June 30th, 2024. 22, accept a donation from Friends of Gardner Field for $110,000 to be used towards the construction of the Gardner Playground. 23, accept a donation from Even Murray's Farm to Table for charcuterie cups valued at $75 in support of the Manufacturing Resource and Career Fair. Number 24, accept a donation from KJ's Cafe for sandwich wraps valued at $75 in support of the Manufacturing Resource and Career Fair. 25, accept donation from Middlesex Savings Bank for $3,000 to support the 2023 Summer Concert Series and special events. I'll entertain a motion to accept consent items 9 through 25 inclusive.
So moved.
Second.
Moved and seconded. All in favor say aye.
Aye.
Opposed? Abstentions? I'll take one more motion.
Move to adjourn.
Second.
Moved and seconded. All in favor of adjourn, please say aye.
Aye.
Opposed? Abstentions? Thank you. Good night.